Of the Appellate Division, 4th Department. Hear ye, hear ye, hear ye. All persons having business to do before this court shall draw near, give their attendance, and shall be heard.
Thank you. Please be seated. First case scheduled for oral argument this morning is People versus Swanson, case number 911.
Good morning, Your Honors.
Good morning.
Frank Policelli for the appellate, Mr. Swanton. The argument I'm making on appeal today, why I think this conviction should be reversed, is because I submit to the court that the evidence, when viewed in the light, well, put it this way. The jury was presented with evidence that showed Mr. Swanton to be a bad person and the decedent to be a person that deserves sympathy. The sympathy is completely irrelevant in a murder case. Every murder case has a dead person, okay? The decedent was a 9/11 hero. His wife testified she never saw anything.
Was there any testimony about him being in 9/11, working in 9/11, being a hero there?
His wife.
She testified to 9/11?
No, she didn't. I don't think she said 9/11, but she
Right.
testified that
He was a firefighter.
He was a
In New York,
firefighter.
but there was no reference to him working on 9/11, right?
I don't think so.
Okay, just want to be clear about that.
Okay.
All right.
Well, but besides that, her whole testimony was only to arouse sympathy for the decedent. Just like the prejudicial evidence of the defendant, when asked what color was his cooler, and he said white like me, was to prejudice the jury against the defendant to show he was a bad person. Then this whole firewood issue that they mentioned, which was completely irrelevant, had nothing to do with the case but to show he was a bad person. Now you also show the witness who was also shot, Robitello. This is the crux of the case that I think I'm getting at here. When they charged the jury on justification, the judge charged the initial aggressor charge. Now, if you look at the supplemental record, page 77, I ask that the court also include in that charge the fact that if my client was armed, that's not to be considered. I looked at the Valentine case, the Court of Appeals case Valentine. It was a 4-3 decision.
Yes,
Sure.
Counsel, I don't remember you making these arguments in your briefs about, giving the wrong charge on justification.
Well, do you know why? Because the charge on justification under the Valentine case, the majority, the 4 judges that were with the majority in that case said when the initial aggressor has to be charged because it's a question of fact. So I can't argue against the charge, but I could argue that part of that charge should have included the fact that he wasn't armed. And that's in the record on page 77 of the supplemental record. So the argument I make in my brief, Judge, is that, okay, if you're going to say that's a question of fact, then the jury could, because the argument, if you read the cross-examination of Robitello, he actually admits that when the statement is made by Swanton, this isn't over till you're dead and your family's dead, he never displayed his gun. In Valentine, the guy displayed his gun. And so the argument was mere words are insufficient.
So just so I'm clear, are you arguing this point in support of your second argument in the brief that the jury got it wrong on justification, or are you suggesting what point in your brief does this argument relate to?
The weight of the credible evidence.
Okay, so point 2 in your brief.
Yes.
Okay.
Yeah, that's the main point, Judge.
Yeah.
The weight of the credible evidence, because this jury, I mean, I've always said juries decide cases on who they dislike the least. And in this particular case, they disliked the defendant and they were sympathetic towards the decedent. So they're looking for a way to convict. That's my opinion.
How are we ever going to change that scenario? Looking at the facts,
Because if you look at the facts and you look and you see that there was no evidence to support the fact that he was the initial aggressor because it was just mere words, then you can say that the jury's decision was unreasonable. The touchstone in the Valentine case, both the majority and the dissent, remember, Judge Stein wrote the dissent with Judge Rivera and Judge Wilson concurring with the dissent. And remember, in the Valentine case, the dissent gives you a footnote that basically says that you cannot use mere words alone to show that somebody is the initial aggressor. Plus, I will say this. The only person that says that Swanton made that statement is Robitello.
Let's put aside the statements that were made or not made. Do you think Mr. Robitello's testimony at trial, accepted as true, disproves your client's justification defense beyond a reasonable doubt? If the jury believed Robitello and the shooting went down as Mr. Robitello testified to, would you agree that there's no justification defense here?
No, I'm going to tell you
Under
why.
his own testimony, it establishes self-defense by your client?
I'm sorry, repeat your question again?
If the jury believed Mr. Robitello,
Right,
his testimony about what happened in the driveway there,
right,
slash garage,
right.
is does that not negate your client's justification defense? If they believe Robitello, I know you don't believe him. You think he's suing and he's got other motivations, but let's assume the jury believed Robitello and the fight happened the way it did. Does that not negate your client's justification defense?
No, because this is the key, Judge.
Okay.
He says that he never displayed the gun. He only uttered mere words. And that's when he says the shoving started, which escalated into a fight where all the forensic evidence shows that Robitello's view of what happened. And now you say, can you say that he's, if you accept his view? Well, his view was that my guy fired the gun while he was facing the road, standing up. Judge, all the evidence shows that the gun could not have been fired facing the road. That my guy was on the ground. If you saw the exhibits that were submitted of the scrapes on the back, on the pants.
What you're saying then is Robitello was either mistaken or he was lying at trial about what happened there.
Yes,
Okay.
that's true. That's why I say the weight of the credible evidence, this court could review it.
Do you agree or disagree that the evidence of justification from the defense was stronger at the prior trial than it was here? Your client testified at the prior trial that I got hit, that the victim here was straddling him and punched him 12 to 15 times in the face. There was no such evidence in the most recent trial. All we had was your client's statements to the police at the station.
And
So the evidence of justification was stronger the first time than it was the second time.
no, because he may have said 12 to 15 times when he testified, but he did say in his statement to the police that he was being pummeled with fists coming around left
He
and
said
right.
to the police he never was on the ground. He didn't get knocked down. He said that in the first trial. He got knocked down and the decedent was straddling him and pummeling him with his fist. We didn't hear that in any of the statements to the police. We heard a couple of punches. We didn't hear anything about being on the ground, being straddled, unless I missed it.
Whether he actually said that or not, the physical evidence shows that he was on the ground. Number one, his pants. His pants had the footmarks of the shoes that the decedent was wearing on his pant legs, number one. Number two, the shots that went into the decedent were on an upward trajectory, the stomach to the shoulder and to the garage that was behind the decedent, okay? So he had to have been on top of him when he was firing his gun. And believe it, and here's the thing, he doesn't pull the gun out until after he's getting beaten up. So that's where the justification comes in. And,
But there's no evidence the other people had any weapons, correct?
There's no evidence that they had any weapons,
Right.
but he knew that he possessed weapons. Plus, the guy comes over to his house, his blood alcohol level was 0.21. The Robotello's blood alcohol level 3 hours later was 0.14. There's no evidence that my guy was even intoxicated. So he's at his home, they come to him. There had been a dispute at the party that they were all at. He left, they came to him. And that's when. I'm
Was
sorry.
there, I remember some proof in the record, sir, that talked about how maybe your client even lured them back with a promise of an apology.
Yes,
Okay, so they didn't just come back to have a fight with him. Maybe they came back to hear the apology.
remember this, Robotello said that he went there first. He talked to him and then he said that he would bring Krempler back and there would be an apology. And when Krempler came back, there were words that were spoken, there was an argument, and there was never a chance for him to finish talking to the guy.
Okay.
So your case, your argument really is that you would acknowledge, I think you would, that you can't pull a gun if you're in a fist fight. But your argument is you could if you're losing that fist fight and you're in reasonable fear that you're going to die.
Correct.
And that your client, it just wasn't a fist fight. He was about to get killed. And that justifies him pulling out and emptying 9 bullets, emptying his clip.
Yeah, I mean, you say he was about to get killed. I suppose if anybody's ever been in that situation where somebody is beating them up pretty badly, that you always run that risk that something that you could die from that.
Right. It's just a question of, is there evidence that he was in imminent fear, reasonable fear of imminent death, based not on his testimony from the other trial, because he didn't testify here, based on what he said to the police. He acknowledged that, well, what he did was maybe wrong. He didn't have any really significant injuries. He had a little scrape on his head. Didn't even appear, if you're getting pummeled in the face, you would think there would be some indication of that shortly thereafter. He didn't seem on the videos that I saw. He appeared to be perfectly fine physical condition.
Well, I mean, you get pummeled on the side of the head. I don't know if you ever played football, but you get hit on the head, you're going to get, dazed a little bit.
Okay.
So that was his reasonable fear. I mean, and the problem, in my opinion, this is why I asked the court to consider this under the weight of the credible evidence, is that he was improperly, his character was, the bad character evidence came in that should have never have came in. That had to influence the jury. So you got the bad evidence, the firewood, the white like me statement,
I think the people would argue that the firewood showed motive. There appeared, your client, according to testimony, was upset that he got shorted when the 3 of them bought wood together. And that was a dispute that they had earlier in that day. So they would suggest, I think, and they may when they get up here, that why would your client just kill his friend? There has to be some reason, and they would say that the firewood incident goes to motive. Not a very good reason to shoot your friend, but it is relevant.
except Robotello said that had been quashed and nobody was concerned about that. He testified to that. And, if anybody would have been upset about who got more firewood, it would have been Krempler. So the firewood issue, and then don't forget, you've got the 911 call that Robotello makes where he's crying. So the purpose of the call had already been satisfied, and he's talking about the guys dying next to him. All that goes to the sympathy for the decedent that's completely irrelevant to the actual case itself. What happened after the shooting, where these people went, whether they were in fear, that is prejudicial, coupled the prejudicial sympathy for the decedent, coupled with the prejudicial evidence against the defendant, influenced that jury so that they could not fairly assess the jury charge on justification, especially when the initial aggressor charge omitted the fact that just because he had a gun could not be considered, and I couldn't argue that the jury charge should not have been given because Valentine's case says it's got to be given.
All right, anything further?
No, unless you.
Thank you very much.
Thank you very much.
Thank you. Good morning, Justices. May it please the court. My name is Jeffrey S. Carpenter. I'm the Brooklyn County District Attorney. And as I'm sure you know from the record, I'm the one that prosecuted the case personally with Mr. Policelli as the defendant. I think when we talk about this weight of the evidence argument, and I think Justice Bannister, you hit the points raised on oral argument today were not in his brief. He's arguing the length of the jury deliberation in his brief, and it certainly could not have been adequate, even though the first thing he says when he stands up in his closing is, ladies and gentlemen, I've been watching you and I know you've been paying attention to this. This wasn't an overly complicated case in that it wasn't a whodunit or there's any question of who did the shooting here. It was a question really that came down to, was he justified? And as the court, I'm sure, is aware, the first reversal in the initial trial was because the instruction was not given. It was given here. And at the time the instruction was given, counsel did not object or take any exception to the court's instructions on the, especially in light of his argument today, who is the initial aggressor. And counsel doesn't have it right. Initial aggressor, when it comes to the use of deadly physical force, is the first person who uses or threatens the use of deadly physical force. We're beyond the mere words at this point in time. And the evidence is clear. No one but for the defendant possessed any deadly instrument or deadly weapon during that exchange. When we talk about the cries of sympathy, I would direct the court's attention to Mr. Policelli's opening statement, where he's the first to mention that the decedent is a New York City fireman. I didn't do it in my opening. There was very little questions as to what he did as a fireman in the record. And in fact, there is nowhere in the record that anyone referred to him as a 911 hero, as Justice Lindley pointed out. It's just devoid in the record. The initial aggressor charge was properly given in this case by the court. The argument that the question was asked as to the color of the cooler is just erroneous. I did not ask the question, what color was the cooler? That did not come out like that. It came out in an ongoing
The question
answer.
was, did he say anything else? And you then explained in a sidebar that you had no idea that this witness was going to testify, that she hadn't made that white like me statement in the police reports and any of your prior testimony, and this came as a surprise to you.
That's
And there was a charge by the court, to try to downplay that comment.
absolutely, Your Honor. And I would direct the court's attention to the appellant's brief on that, because not only did the court give a curative instruction to alleviate any prejudice to the defendant, but counsel in the brief cuts the judge's instruction in half, leaves the second half of that entirely off. I don't know if you caught that.
We saw the whole thing.
Yeah, the judge not only sustained his objection, struck the words "like me" from the record, and then gave a very thorough curative instruction that we presume in all the cases before the Fourth Department that they did follow, absent any evidence that they did not.
Everybody involved in this case was white.
Excuse me?
Everybody involved in this case was white.
Correct.
Race was not an issue at the trial. There was some indication. I saw a varying number. There was at least one black juror.
There was one, yes, Your Honor.
Were there two was there, because counsel had said down below there were two blacks, I believe.
Yes.
He used the word, I think, two members of a minority.
There was one minority member on the jury. Yes.
And it's your view that that was not so prejudicial, the statement the defendant said that his cooler was white like him was not so prejudicial as to necessitate a mistrial?
Correct, Your Honor. It had no prejudicial effect at all, given the facts of this particular case, and then coupled with the judge issuing a very thorough curative instruction, I think eliminated any possibility that was held in any negative light towards the defendant.
How about the 911 call? It did seem to be irrelevant and unduly sympathetic to Mr. Robitaille toward the end there.
Yes, Your Honor. We had 6 pre-trial evidentiary conferences in this case, and I'm sure in the record you can see the judge very thoroughly went through photographs, videos, as well as the 911 call. The judge had the 911 call. We played it as part of one of our conferences. And of the approximate 11-minute 911 call, 30 to 40 seconds of it is when William Robitaille's daughter, Taylor, was heard on it. But the reason for entering that 911 call is twofold. Number one, it very accurately portrayed to the 911 operator what occurred on that day. Certainly more so than the defendant's 911 call where he doesn't answer a single question. And number two, when listening to that call, especially since counsel has made an argument that, you know, much of this scuffle, as the defendant called it, occurred inside the garage, when William Robertello is merely talking to his dead friend at that point in time, who's laying right next to the Kubota, he's talking in a very low voice, natural voice. He's saying, Scott, are you okay? That's very important for the reason that it places the body next to the Kubota in the driveway where all of this event occurred. Nothing occurred within that dwelling, as the defendant wanted the jurors to believe. And I think when we get to number one, the initial aggressor, I think Your Honor, again, hit it right on the head. The defendant, we heard from the defendant. Was it right what I did? No. Was I in fear for my life? Well, you know, I don't know. Well, the first part in determining whether or not you're justified in using deadly physical force is, did the defendant himself believe it was necessary? And he says it wasn't, because he doesn't believe he was in fear for his life. We heard that directly from the defendant in the 11-hour video, and he did not testify in this case. And also in that 11-hour video, as Your Honor pointed out, he says he does not recall ever being on the ground. William Robertello says they fell, I believe referring to Scott Krempler after he's shot dead. He fell flat down on his face. But the defendant himself says, I have no recollection of us being on the ground.
He didn't testify to being straddled over by the victim and being punched in the face 12 to 15 times.
He did not testify at all.
He did say he got punched in the face a few times.
He did, yes.
How about if you could turn to the sentencing issue, the court gave the defendant consecutive sentences. And one count was he was not charged with assault in the first degree of murder. He was charged with felony assault.
Correct.
Does the law allow you to get consecutive sentences for felony assault with the principal crime?
I believe it does, Your Honor, yes. Unless there's a single act which precipitates both crimes. And in the brief, as I point out in the McKnight case, when you have several shots, in this case, 9 separate bodily movements of pulling the trigger, then consecutive sentencing is permissible by
Was
the
the
court.
defendant in McKnight charged with felony assault?
No,
Right. So that's a difference here.
is correct.
I agree with you. Under McKnight, if I fire 8 shots into a car and I hit 2 or 3 people, I could get consecutive for that, even though it's all within a matter of seconds. But your office charged him with felony assault. And I'm just curious whether there's any cases that allow consecutive sentences for felony assault and the crime that he was committing at the same time, the other felony. I haven't seen any.
Yeah, and you know, I put the cases that support our position that we found also. There's no case directly on point, but I believe that, Your Honor, there's no reason to have a felony assault statute then if you cannot hold somebody responsible for additional consequences from committing the initial felony.
Right.
I
I think there are cases on point. They say that you can't get consecutive sentencing on the felony assault. But I'll take another look at that.
Okay, thank you, Judge.
Anything further?
Any other
All right, thank you.
Thank you.
You want me to expand the sensitivity?
We don't have any rebuttal,
Okay.
but we do have post-argument submission.
Okay, thank you, Judge.
Thank you. Case 912, People versus Darian Govan, 912. Good morning, Councilman.
Good morning, Your Honors. Alexander Prieto on behalf of defendant and appellant Darian Govan. This morning, I plan to focus on Mr. Govan's direct appeal and then briefly address the first 440.10 motion at the end. Turning to the direct appeal, the appeal waiver in this case is unenforceable, at least as to the suppression issue presented here. The trial court told Mr. Govan that he was waiving the right to review of most claims, including a claim, in the trial court's words, that certain motions or suppression decisions were wrongly decided. That raises the question, which ones, which motions, which suppression decisions are within the scope of the waiver? It can't cover all of them because the court is telling Mr. Govan that it only covers certain of them. Now, certain, like in a lot of words, can mean different things depending on context. But in this context, it's equivalent to some, just like it is in, for example, the phrase, there are certain things money can't buy. To say,
If the court said certain suppression motions, including the one that you filed, it would be a different story.
it would be.
But the word certain is not in the pattern jury instruction.
It's not in there. And there's a good reason that it's not in there because it introduces uncertainty and ambiguity. There were multiple suppression motions here, a motion to suppress statements, motion to suppress physical fruits, gun. So there's more than one suppression motion. Saying certain, like I said, getting back to my example with money can't buy, if you say if certain things money can't buy, you're also saying, well, there are some things that money can buy. And the same thing applies here. When the court's telling him this waiver applies to certain suppression decisions, it's also telling him that it doesn't apply to some of them.
But didn't the waiver, both oral and written, designate specific items that were waived?
There were in both specific items designated as surviving the waiver.
Right,
Yes.
that's correct.
Yeah. Nothing in the language, either written or oral, indicated that that was an exclusive list of the things that would survive the waiver. And the trial court's oral language indicated that, in fact, there were some suppression motions that would survive the waiver. So that ambiguity, that imprecision in the language is fatal. It renders this appeal waiver unenforceable, at least as to the suppression decisions, because we can't tell which ones Mr. Govan understands it to apply to.
Want to address the photo array?
Yes. Moving to the merits, the point on the photo array that I'd like to emphasize is that the people have the initial burden of establishing an absence of undue suggestion in a photo array procedure. This case requires a court to apply that established framework to an unusual set of facts. It's undisputable on this record that Mr. Govan, in the photo used in the array, he's wearing a striped jumpsuit issued by Monroe County Jail. It's also undisputed.
That's undisputed. The dispute is whether a reasonable person viewing that, just a small portion of the jail garb over the right shoulder, would realize that that's jail garb.
Enough.
There is no words. There's a photograph in the record of him from behind, and obviously you can see the words jail on it. But in the photo array, I'm not sure even someone who's been in that facility as an inmate would recognize that as jail garb. That's the issue.
Yeah, my position is that enough is visible that someone who is familiar with that, someone who perhaps had spent time in Monroe County Jail, enough is visible that someone familiar with that type of garment might pick up on the jail origin of the jumpsuit. And that would lead him to say, well, I'm not so sure it's this guy, but he's got the jail clothes on, so maybe I should identify him.
I think if it were an orange shirt, you might have a stronger argument. I'm not saying your argument doesn't have merit, but to me, when I saw it, and I've seen many of these, I didn't recognize that as anything worn in a local facility. But we'll look at that issue. Then you have an issue on the voluntariness of the plea, I believe, as well.
Yeah, on the voluntariness of the plea, the point that I'd like to emphasize is that well, it's not strictly going to the voluntariness of the plea. It's what kind of inquiry the trial court needed to conduct into the voluntariness of the plea. And the point I'd like to emphasize is that where the issue is the credibility of defendant's allegations in support of a motion to vacate, under CPL 440.30, the court can't dismiss outright without a factual inquiry unless there is no reasonable possibility that the allegation could be true. That's the words of the statute. That's a very high level of incredibility. Mr. Govan's allegation here, in essence, was that he felt compelled to plead guilty because his attorney had told him, if you don't take this deal, I'm not going to represent you. That may not be something an attorney usually says. Not really something they're supposed to say. But it is not so impossible of belief that an attorney would say it to raise Mr. Govan's allegation to the level of incredibility required to forego a factual inquiry under CPL 440.30.
Was it incumbent upon Mr. Govan to discuss what was said during the colloquy? Like, have you been threatened? Has anybody coerced you? And he denied all of that. Is it important when he says what the attorney really did in 440 motions, is it important for him to address, that's why I answered those questions that way, or is that sort of implied? And is it enough to be implied? Yes.
Those are exactly the sort of things that the trial court could have asked Mr. Govan by conducting a factual inquiry. He did enough to put it in issue, and then there needs to be a factual inquiry. Like the cases say, it doesn't need to be a full-blown evidentiary hearing, but a chance for Mr. Govan to, as a pro se litigant, present his claims to the court more fully than he did in perhaps this written document, and a chance for the trial court to ask the questions that would enable it to make, in the words of the Court of Appeals, a prudent and informed decision. The trial court didn't do enough to do that here.
If your client's claims in a 440 are belied by the plea transcript, if a defendant says, I was coerced into pleading guilty here in a 440 motion or a motion to withdraw a plea, but in the plea transcript, the court asks, as here, did anyone force you or coerce you in any way to enter this plea? The defendant says no. Don't we usually say a defendant's claim is belied by the plea transcript and we reject it on that ground?
Well, in CPL 440.30, it says contradicted by the record and under all the circumstances, no reasonable possibility of relief. So a contradiction with the record, any contradiction, is not necessarily enough to permit foregoing a hearing.
Doesn't that go back to Justice Nowak's point, though, that it was incumbent upon him at some point in his papers, at least, to be more specific and allege these things? That he was, for example, he was forced by his counsel, that he should have.
He did to explain what his counsel, according to him, said to him. Now, the things that he described are not necessarily, in my submission, excluded by any of the questions that were asked during the colloquy.
Well,
they're not
there's a couple
directly
of them.
contradictory.
One of them is, are you satisfied with the representation you have received from your attorney? The defendant says yes. Another question, are you pleading guilty on your own free will? Answer yes. Yet another question, have you been threatened in any manner to get you to plead guilty? Answer no. What's the purpose of a judge asking questions like that during a plea during when the defendant pleads guilty? If the defendant can just say something totally different in a motion and then get a hearing on it, why even ask him in the first place?
Well, the court needs to ask those questions to ascertain if there's enough of a basis at that point, based on what's in front of the court, to find that the plea is voluntary and accept it.
Good. It would seem that your argument is that the court always has to do an inquiry. That as soon as he says, I was coerced by my attorney, despite the fact that we have things in the transcript that contradict it, that as soon as he says it, without elaborating, without explaining, without saying more, that the court then has to go back, pull out the transcript and say, but you said yes, no, yes, no to these 6 questions, et cetera. And then it's incumbent on the court to do it in every instance. Is that your argument?
Not in every instance. 2 things, because first, it has to, doesn't have to be a full-blown evidentiary hearing. Just be asking Mr. Govan a couple of questions. And there will be some cases, like I've described in my reply brief, there will be some cases where the contradiction is such that it's enough to make it within that no reasonable possibility standard. Like, for instance, in one case, if the defendant is saying that, well, the attorney said these things to me after I took my plea. Well, that is, and it's not reasonable to believe that that would compel him to take the guilty plea because he already took the plea. Here, it wasn't an extremely thorough questioning during the plea colloquy, and there was.
What questions should have been asked by the court that weren't? Did your lawyer threaten you that she was going to quit the case unless you pled guilty? mean, this is not a question that the court would think of. What else should have been asked here that wasn't to ensure the voluntariness of the plea?
I'm not necessarily saying that the court should have asked more, but I'm at that point, but I am saying that applying the language of the statute, when Mr. Govan made the allegations that he did in his motion, the court was at that point obligated to ask.
So that's an interesting argument. If you're right, then it's a really low bar on getting a hearing on a 440. Maybe that's a good thing, maybe it's a bad thing, but if we agree with you on that you can contradict your statements at a plea colloquy in a 440 motion, and then you're entitled to a hearing, people are going to be getting hearings all the time.
I mean, here, Mr. Govan described it, the discussions in detail. He described them in a way that was not outlandish,
But isn't the
and that
stand-
was enough.
The standard here is abuse of discretion. Correct? You don't disagree with that. In the Court of Appeals, in this People v. Samadarov case, you familiar with that case? Basically says it's permissible to do what the court did in this case, not to have a hearing.
The court says that, Court of Appeals has said that there needs to be enough, doesn't have to be a hearing, but they do use the phrase limited factual inquiry. And People v. Tinsley, that's what needs to be done unless you have that incredible belief
But you
standard.
agree it's an abuse of discretion standard, you know.
It is an abuse of discretion standard. Where the question here is, was foregoing a hearing within the court's discretion? And I submit that it's not.
Thank you, counsel.
Thank you.
Good morning. May I please the court, Christina Harper for the People. As to point one regarding the waiver, I would argue that the record here is clear that the waiver of appeal manifestly intended to cover all waivable aspects of the case.
It's not what it says, though.
The judge did use a word certain. However, Your Honor, I would argue that the defendant has very strained interpretation of a word certain. What also the court should look at is that the defendant here signed a written waiver that specifically listed the specific issues that are surviving the waiver of appeal, and suppression issues were not listed there.
Would it be a better practice for the people in a given case, when you have a plea, to go through the rulings that the court's made in that case, one by one, whether you have 3 rulings or 4 rulings or 40 rulings, would it make sense to do that at the time of the plea and just say, all right, this is what's waived, this isn't, so that everybody's clear on it? So we don't have all these arguments about certain, not certain, this one, that one. What if they don't mention suppression hearings at all? We have a lot of cases like that. Don't you think it's better practice to go through them one at a time?
Your Honor, under the current case law, this is not required.
No, that's not my question. The question is whether or not that's what we should be doing from now on. In Rochester, Buffalo, Syracuse, everywhere else throughout the district.
Your Honor, I would disagree that this is something that is necessary to do in each and every case. And this is simply because it's really difficult to foresee what possible issues can defendant raise on appeal subsequent to him taking a plea with a valid waiver. And this is why the Court of Appeals held, and so did this court, that the waiver of appeal does not have to specifically list suppression issues.
I'm aware of the precedent, which is why I asked the question in terms of good practice. But I'm also aware, as are you, that the standard's knowing, intelligent, and voluntary. And I wonder, despite all this precedent, whether it's really knowing, intelligent, and voluntary if you don't go through them one by one. If we really don't know, especially then when you get this, language like certain. Some of them, was there more than one? I mean, it makes it challenging, don't you think?
Your Honor, I would disagree because for the simple reason that there are only certain issues that survive a valid waiver. And even the written waiver is very clear that it clearly states that your conviction will be final.
That's bad language under Thomas. You say final, it's invalid. I'm not sure it says the word final. If it does, though, then you lose under that. But
No,
it's,
Your Honor,
it's not that hard to comply now, since People versus Thomas, the Court of Appeals basically said, read the model colloquy. CJI, the criminal jury instructions, have the model waiver colloquy. A lot of judges use it word for word now. This case was from 2021, so I'm not criticizing the trial judge, even though Thomas was 2019, but the court freelanced here. It did not follow the model colloquy, not even close. And then when you're not following it word for word, then you make a mistake here and you use the phrase certain suppression motions. I would think, again, it used to be very difficult for trial judges to understand what a valid waiver is. It's not anymore. Court of Appeals has made it clear what you need to read. It wasn't read here. And the issue is whether that extraneous language rendered this unclear or involuntary. But that's the danger that is run when you freelance with these.
Yada, I would also note that even in People versus Thomas, the Court of Appeal did specifically say that no particular litany is required. Certainly, it is best practice for every judge to simply read the model colloquy. However, it is not required, and based on this particular record, the waiver, I would respectfully argue, is valid.
With respect to the photo array, you want to be heard briefly on the merits of that one?
With respect to the photo array, certainly I would start with the burden of proof that the people have minimal burden of production in this particular hearing, and the people did meet that burden. The court correctly held that this particular photo array is not was not suggestive in any way, shape, or form, because the clothing that the defendant was wearing does not have any identifying characteristics that would make one.
Somebody who had been in jail in that community or visited somebody in jail might be able to recognize that garment as coming from the jail.
There was nothing elicited on the record that this particular
Right. That's why they say it was your burden, your initial burden to come forward, and you had to show that. And that's where you didn't meet your burden according to the defense.
Your Honor, this was not something that we had to establish. We had to establish that police conduct was reasonable, and we had to establish that we had to go forward with the evidence of undue that there was no undue suggestiveness. However, the burden of proof lies on the defendant, not on the prosecutor.
So the burden shifted. They should have come forward and said, look, this witness is familiar with those types of shirts. And for this reason, that reason. And they didn't come up with, nobody had any evidence of whether this witness understood what the defendant was wearing.
They had an opportunity to cross-examine witnesses. They could have subpoenaed their own witnesses for this particular hearing. The people here met the burden, and just looking at the photo array, there's another individual in number 2 who is also wearing a striped shirt. Also, the hearing. It was elicited during the hearing that the identifying witness concentrated on the eyes and hair. And I would also point out the fact that there was no positive identification.
Did the witness even identify the defendant?
No, there was no positive identification
There was
at all.
no positive ID. Is that even suppressible? Can you suppress a non-ID in the first place? I mean, why are we even arguing about this?
Right. So the people did conduct, so there was identification procedure, and in the abundance of caution, the people did file 7-1030 notice and simply disclose the fact that there was this identification procedure.
I would think the defendant would want that at trial. I would think that the defendant would want that evidence. Hey, you looked at it and you weren't even sure who it was. But in any event, we'll take a look at that, and we thank you for your time.
Thank you, Your Honor.
Case 917 is People versus Jones Watkins. Mr. Sarando and Mr. Casella for joining us virtually this morning. We believe they are. Mr. Sharando, Mr. Casella, good morning. You may proceed after you unmute yourself.
Good morning, Your Honor. May it please the court. I can't see the court, but the court can see me. That's the important thing, I guess. John Sarando from Syracuse on behalf of the appellant, and we will rely on our brief unless the court has any questions, Your Honor.
Hearing none, thank you. Mr. Casella, do you wish to do the same?
Your Honor, I would do the same. Thank you.
Thank you for being available.
Thank you.
Thank you.
Case 918 is People versus Wyatt. Stair, good morning to you.
Good morning, Your Honor. Stephanie Stair for Mr. Wyatt. Your Honors, it was ineffective assistance of counsel for defense counsel to not have requested a PC hearing in this case. A simple viewing of the body-worn camera footage shows that this was not a slow, methodical journey through the DeBoer levels, but rather 0 to level 4 in 18 seconds. I can see no legitimate strategy for not requesting a PC hearing. This court under Roots and Barber.
Counsel?
Yes.
The court even kind of hinted to the
Yes.
defense attorney, maybe we should do this, didn't it?
Several times when Mr. Wyatt raised complaints about his attorney, which sort of goes to point 2, the court's response, you're correct, Justice Bannister, was, don't worry, we're going to have a suppression hearing about your arrest.
Right. And that never happened.
Never happened.
And I think from the record, we can assume it's because defense counsel didn't push for it.
Correct. It was not in her omnibus. She never mentioned it on the record.
Right. Okay.
Yeah, and your point is that maybe it would have been successful, maybe not, but should have at least it would have been a dispositive motion on
Absolutely.
the charge.
Absolutely.
It seemed stronger on the surface than the special motion that was made with respect to the statements. Seemed to be very little chance of winning that one.
Correct. And I would argue that those statements are fruit of the poisonous tree. They are,
Right.
Those would also fall if the initial stop and search were challenged.
If we agree with you that counsel was ineffective in failing, it's a single error of ineffectiveness. There was a jury trial here. Your client
Correct.
was convicted. Would we vacate the jury trial? Would we keep the jury trial in place for now and remit for your client to have a lawyer file a suppression motion for a MAP hearing? And then we'll await the outcome of that hearing to deal with the verdict. What do you think the law requires us to do if we agree with you on the merits?
I think this court, if you agree with me, needs to vacate the jury verdict and go back basically to square one.
And tell us why.
The point of ineffectiveness was almost at the very beginning of this representation. So it colors the entire course of the trial, of any court appearance, even sentencing, honestly. And Mr. Wyatt made it very clear almost from the get-go that he was unhappy with his attorney. And when, a single point of ineffectiveness can overturn an entire case. And when it's something so major like this, like I said, it taints the entire representation of Mr. Wyatt from almost
So the lawyer's failure to bring a colorable suppression motion then brings into question her representation of the defendant at trial, even though you're not pointing out any errors or mistakes at trial. But we would presume that she didn't provide meaningful representation at the trial because she didn't file a particular motion. That's the argument, I think.
Right. I mean, she shouldn't have even gotten to a trial. If the suppression motion were successful.
From your brief, you mentioned both the body-worn camera footage as well as the officer's testimony that points toward it being a level 4 and not a level 3. I have a sense in my own mind of how you got there, but it wasn't laid out in your brief, and I'm not sure I'm right. Can you walk me through sort of what was it? The grabbing of the arm? Was it the statements that were made, was it a combination?
Right, so it's a combination of many things. And so he was pat frisked and cuffed almost immediately, the 18 seconds. The 911 call wasn't definitive that it was a gun, right? So we don't know for sure. He said it could be a gun, it could be a cell phone. He has more than he should in his pockets.
Right, we know the information he has going in, that's
Right.
clear from the 911 call, but the question is the interaction once he's walking up to the gas station.
Well, there's nothing connecting. There's nothing to show that that person is the same person the 911 caller was referring to.
Okay.
And there's not enough time to establish that really, because
He
he goes
matched the
from,
clothing almost exactly, and he was going into the gas station where the 911 caller said he was going.
right.
But would the initial intrusion here was a frisk, level 3, right? He stopped and frisked him. He found the weapon and then he handcuffed him. Handcuffs would arguably be level 4. You need probable cause, but it sounds like, to answer Justice Norris' question, would you agree that it was a level 3 at the time the gun was found?
It could be. I could see the argument to be made for that. However, it's so close in time. The frisk and the cuffing is almost instantaneous if you watch the body worn
But
camera.
either way, you think even if it was a level 3, there wasn't reasonable suspicion.
Correct.
Based on the nature of the call. It looks like a black cell phone, but then again, it looks like a gun. He's got too much stuff in his pocket. That's enough maybe to inquire a level 2.
Mhm.
But not stop and frisk on 3 would be the argument. Now, we're getting into the merits of a motion that wasn't even
Right.
made, but
Right.
we have to decide whether there's a colorable motion could have been made. So that's why we're getting into this. And
Right. I would also point out, sorry.
No, let me let you answer first and then follow up.
I was just also going to point out that I believe it was Presiding Justice Lindley that pointed out he matched the description. It was a very basic clothing. There was nothing specific. It was, black shirt and jeans. It's not,
And a hairstyle.
black shoes, black sneakers,
Right.
Jordans.
but there's, it's dark. From the body worn, I can't even really tell that necessarily matches.
See,
I don't know if that questions.
I thought that the argument was going to be, and now I think I'm wrong. I thought the argument was going to be that the grabbing of the arm, telling him to stop grabbing the arm, that's the arrest, not the handcuff. Because I think the grabbing of the arm and telling him to stop happens before the pat frisk.
Right.
And the handcuffing happens after. That's what I thought, but
It happens almost, one right after the other. He grabs his arm and, pats around and then handcuffs him. It's a matter of seconds between the arm grab and the cuffing. From my memory, I would obviously defer to the actual video, which your honors all
The
have.
fact that we're debating this and I'm unsure the legality of this supports your argument that a motion should have been made. Maybe you're going to lose it below,
Right.
but there's no strategic reason not to bring it. It's clearly above that little or no chance of success standard.
Absolutely.
Question is, does it get to the colorable standard, which is a fair probability of success? We're in between. If it's colorable, then it was ineffective in not bringing it.
Right.
What happened below? Because the trial judge made it sound like he was gonna combine the hearing or something, and then and then the defendant didn't show up for the initial Huntley hearing, correct?
So my interpretation is, I think the judge below assumed that it was going to be a PC hearing because it's a gun case. There's almost always a PC hearing in a gun case. And he just, I think he kept misspeaking. I think it's really important to point out that the DA clarified more than once, hey, just so everyone's aware, this is not a PC hearing, right? And everyone's like, yep, not a PC hearing. So there were so many opportunities for defense counsel to be like, wait a minute, I screwed up. This should have been also a PC hearing. So it's made very clear going into the hearing that it was not going to be a PC hearing.
We have a good grasp of that issue. You have some other issues you want to briefly touch on before your time is up?
Yes, Judge, thank you. Point 2 is related. 3 and 4, I will skip over unless there are questions. For point 5, I only feel the need to say something on a harsh and excessive argument because at sentencing, the court referred to this as a run-of-the-mill case with no mitigating nor aggravating factors. and then sort of walloped him with the sentence.
What happened to, I think there was, the judge may have been influenced by the fact that your client was released pending prosecution and picked up another weapons charge.
Right.
He was prosecuted separately for that, I assume?
He was, but it was still in front of this judge and actually on the same day.
What
So
happened with that charge?
he was sentenced on the trial, and then immediately thereafter, on the same docket, same day, pled guilty to the second set and was sentenced to consecutive time, which was required by law.
How much consecutive on that one?
He got 3.5 plus 2.5. So his aggregate total was 9.5. And the judge, it was always, both cases were always in front of the same judge. So he knew that he was going to have to,
Right.
by operation of law, give
Yeah, I mean, maybe
consecutive
that,
time.
look, that's a factor that if you let somebody out on a weapons charge and then they just go out and pick up another one, I think that's a valid consideration. That sentence, I'm not sure 6 was warranted here, but there was an offer of 2, but that was before he got arrested again.
Correct. And then the global offer for both sets was 4.5 plus 3. Like I said, I just mention it because the court did say there was no mitigating nor aggravating factors, but then, went pretty far away from the minimum, in my opinion.
Right.
If there are no other questions,
Well,
I
thank
would
you very
much.
much.
Thank you.
May I please the court, Georgina Harper for the people. As to point 1, ineffective assistance of counsel, this is a single error case. And certainly what the standard is that only if the issue is so clear cut and dispositive that no reasonable defense counsel would have failed to raise it. In my brief, respectfully, I argued that we had level 3 DeBoer, not level 4. Certainly there was no hearing requested. However, the trial testimony of the police officer sheds light on how the arrest happened. He received, there was a 911 call from an identified individual who identified the person who he thought had a gun. What also precipitated
He thought he had a cell phone or a gun.
correct. What he also states in the call is that prior to him calling 911, there was an incident at the Burger King where
But
he's a manager.
he was unable to say that that was the same guy.
Correct. However, he also pointed out that it was suspicious that the individual was basically lingering around outside of Burger King for an extended period of time.
Right. In your view, it's relevant. The incident earlier where a customer was dissatisfied with an order and said, I'm coming back with 20 people and we're going to kill you. Later that day, this defendant is outside the Burger King loitering for an hour or 2 with something in his pocket that looked like a cell phone or a gun. It's not irrelevant what happened earlier here to whether there was reasonable suspicion. It's not nearly as incriminating as if he was the one who threatened to shoot it up, but it's not irrelevant either.
Right. So that is the fact that the police officer did have knowledge of going into it. Another important point is that the 911 caller, an identified manager from Burger King, specifically said that this individual is now walking towards the gas station, and the police officer arrives shortly thereafter and sees this individual at the gas station, right outside of the gas station. So he approaches him and the individual walks away from him. It is captured on body-worn camera footage. He's trying to get the individual's attention as he's walking inside of the convenience store. And then what is important is that the police officer does explain the pat frisk. What had happened is he noticed that the defendant was placing his hand inside of the pocket and he saw a bulge. And that's what prompted the police officer to pat frisk. We had level 3 DeBoer based on all the information that he had. And only after he felt the gun in the defendant's pocket, and he testified extensively at the trial as to his training and experience regarding guns and how he felt that this was a gun in the pocket. And only then did he detain the individual, took out the gun out of the pocket. It's not level 4 if the police officer does not go inside of the pockets, and that's what he did here.
You may be right about all that, but that doesn't answer the question we have to answer. is whether there was a colorable claim to be made. These are all arguments that you can have before Judge Dollinger if it were to get remitted. And then we'll see what he does and come back to us if that's the way this panel votes. But it's not whether the police acted lawfully, it's whether there was a colorable claim that should have been brought and wasn't.
Your Honor, I believe this court also held that failure to request a hearing is not an ineffective assistance of
If there's
counsel.
little or no chance of success.
Correct.
I feel comfortable saying that it's not that low of a chance of success here. Little or no is almost frivolous. This is a close one. Based on the fact, as Justice Bannister pointed out, it was not a 911 call from an identified citizen of a man with a gun. It was a 911 call from an identified citizen of a man with a cell phone or a gun. Little bit different there. So it's going to be it's a close call there, but the argument that the defense is making is that it was worth making below and it wasn't.
Your Honor, I would still respectfully submit that had this motion been made, it would not have any possibility of success based on police officer's testimony and how everything transpired as it was testified.
If we don't agree with you, what then do you suggest we do? Vacate the jury trial as counsel suggests? What other remedy could we impose here?
Should this case, Justice Lindley, you suggested, should this case be remitted just to see if the motion is made and the hearing is held, whether or not the gun would be suppressed, and that would be the definitive answer, I guess, rather than redoing the entire trial.
Understand. All right. Thank you very much.
If you don't have any other questions as to remaining points, I would rest on my brief.
Thank you, counsel.
Thank you.
We're going to call cases 919, 920, 926. Matter of McCants, Baskin versus Mack. Call all three together. I understand they're two different cases, but involve most of the same lawyers and the same parties. Justice Hannah is recused on this appeal. We're waiting for Mr. Pajak. Mr. Muldoon's in the courtroom.
Something is amiss here. Can anybody hear me?
Yes, we can hear you. We can't see you.
Okay, well, I cannot see you either. Let's try this one
Well, as
thing.
long as it's better that we hear you than see you. And oh, there you are. All right.
Okay, sorry about the wrong-
I don't know if you heard, but Justice Hannah has recused on this, which is why you only see 4 judges on your screen.
Yes.
Mr. Pajak, you may proceed.
Okay, the case really comes down to credibility, and the thing that jumps out at me about this case is how does family court resolve the credibility issue when it does not permit Mr. Mack to present his corroborating witnesses? In this case, he had 2 disinterested Buffalo City police officers that he had subpoenaed to testify. The judge had signed the subpoenas. There was an extra day of testimony available. He was ready to go. The judge did not let him go forward. So also, the judge in his decision overlooks Giovanna's testimony where she doesn't see any broken glass in the kitchen. The police records admitted into evidence don't notice any record any damage to the apartment, yet family court judge resolves all of the credibility issues against Mr. Mack and then does not let him call the 2 police officers as his witnesses. This case also involves whether there was damage to property in excess of $250, and petitioner's testimony was that she was giving an estimate. There wasn't precise enough, and I gave you the case law in the briefs.
But the officers were not fact witnesses to the incidents, correct?
No, they arrived immediately after the alleged incident, and I think it was July 5th, June 5th, I'm sorry.
And they were
So
unavailable
they-
during the trial. I'm sorry.
I'm sorry, Judge Green.
And the second part was that they were unavailable during the trial, so it was a question of whether the court abused its discretion not granting based on those factors, then a continuance, correct?
Okay, well, I disagree that they were unavailable. They were going to be under subpoena. In fact, the trial judge signed the subpoena, ducis tecum, so that the defense counsel could call the police officers as witnesses. He signed the subpoenas. Defense counsel was ready, he was able to go. And when they ran out of time on the day that my client testified, well, the judge says, well, we're not coming back for the remaining day of testimony. I'm going to cut you off here. Well, that's not giving Mr. Mack a full opportunity to air his case. I understand that my client didn't get off on a good foot when he immediately asked the court to recuse itself, but at least he should have had at least a fair shake at trial and be allowed to present his evidence.
You said that there were subpoenas, but he never served the subpoenas, right? Isn't that one of the?
Right, they were not yet served. That's correct. The defense counsel prepared the subpoenas. The judge had signed them, and counsel was ready to serve them and had the officers produced on the next day for testimony. I mean, this is not like Supreme Court practice or county court criminal trials even, where you have your witnesses all stacked up, they're ready to go on the day of trial before the jury. Family court's not like that. It's piecemeal. You break up the testimony day by day by day, and you do the best you can with it. And in this case, counsel reasonably believed he had another day of hearing available, and he wanted to produce these witnesses, and they should have been produced.
I noticed in the record that the petitioner testified that she didn't talk specifically about her injuries to the police. I think she said something like, I just wanted them to leave. I just wanted him to leave when the police arrived. Was there anything material that the police officers would have offered that would have been any different than what the petitioner admitted to anyway?
Well, that, you don't know unless you call the officers. And certainly we have the police reports and evidence, but it doesn't substitute for their testimony, but it does give us an indication as to what the officers would have testified to had they been called. And police reports note no damage to the apartment. She doesn't complain of injuries. I don't know what the fellow was else supposed to do. He wanted to call his witnesses, and there's no reason why he should not have been able to.
You want to be heard on appeal 926. I'm not sure you were with us when I said we would hear both the cases together, 926 being custody and visitation.
Yes, between August and September of 2022, my client did cancel some visits. And before then, he had been enjoying overnights. He had been enjoying weekend visitations, whatever it was. So he cancels some visits, and the court reduces his access to 5 hours a week. 5 hours a week, judges, is not enough time really to establish and maintain an intimate relation with your children. That's just simply not enough. And yes, something should have been done to ring his bell to say, okay, Mr. Mack, you should pay more attention here. Don't cancel so many visits, but to cut them back to 5 hours a week, that is a bare minimum.
This order was entered May of last year, so it's been 18 months now. Has his visitation increased from the Sundays for 5 hours, Sunday afternoons? Is that what he's still getting?
I have no information as to what's beyond the record, Judge. I just don't.
Okay, that's fine.
Because he could have, I mean, after 18 months, easily applied for modification if he had been doing the 5 hours a week, correct?
Right. I don't know whether he has or whether he hasn't. I know that the order of protection has expired, and it was fairly recently.
Right.
I think it was on December 7th.
Well, if there's a new order, then this might be moot, but the way it usually works, as you know, because you practice there more than I do, is sometimes people start out with limited visitation. They establish themselves as responsible parents, and then they grow on that and say, can I get overnight? Doing well with that. Can I get weekends? And it grows from there. And that's why we asked the question, among other reasons. But any further final points on 926, which is the custody case? You think he should
No, I
get more
think-
time back at the hearing? You think he was entitled to more than just Sundays afternoons?
Oh, absolutely, absolutely. And he's asking for the normal visitation. He's asking for
Right.
weekends and one overnight, the standard visitation, and I have a case in the brief that
All
points
right.
out to what they.
Thank you.
All right, thank you, Your Honor.
Ms. Hawthorne?
Yes, Judge. So starting with the custody matter, I think that it's important to note that the standard is whether or not he has meaningful access so that he can have a meaningful relationship with the child. To say that there's some sort of regular order would not be the case, as every situation is factually different. And in this particular incident, the court properly considered the domestic violence and its impact on the family in assessing the order. And they had started out with very restrictive access and had moved up into overnights. And then not after just a couple of missed visits, but conduct that was repeated by the father, did they then ultimately reduce the access to daytime. So as the court is well aware, the great difference is given to the lower court, who assessed the credibility here of the witnesses. And they were very clear that they found my client very credible, that she gave detailed and responsive answers, and that the trial court did not find the father to be able to provide any clear and direct answers. And his demeanor at trial was very vague, evasive, and not entirely credible. So when we say this comes down to credibility, the court very much laid out who they found credible, who they did not, and the reasons for that. And moving over to the family offense petition, the request in terms of the officer was actually an adjournment request, a request for a continuance. And that was denied, but it was denied after lengthy oral argument that included an offer of proof. And the court ultimately determined that the request to call the officers was just a hopeful inquisition. It's the failure of Mr. Mack's attorney in not having his witnesses ready to go and not even bothering to serve the subpoenas that caused this issues for his client. But at the end of the day, after a lengthy argument on offer of proof, it was determined that it would not provide any value, as they did not witness the incident. They would only be taking the hearsay or the statements of the parties, which they had already been able to testify to. And so there was no further value in that testimony.
All right, thank you. We'll hear from Mr. Muldoon next, on behalf of one of the children.
May it please the court, Gary Muldoon for the child.
Which time?
The younger child. In this court, in this case, there's an issue of whether the evidence was presented beyond the standard that was required. And I submit that it was legally sufficient to establish both assault third degree and criminal mischief third. This is a preponderance standard. And the mother testified to severe pain, which I submit is equivalent to the statutory standard of substantial pain. And when it comes to the amount of the value, I again submit that using the preponderance standard of her testimony was sufficient for criminal mischief third degree, and in any event would have been sufficient for criminal mischief fourth degree, which does not have
Well,
a
it might be
monetary
because
standard.
of third, because she had to give up $700 security deposit. Isn't that part of the record?
That is also part of the record.
Testified to that, and the third only requires $250 worth of damage.
Correct. So there's various reasons why the monetary standard for criminal mischief was adhered to. When it comes to the issue of a continuance, my understanding was that the father made no offer of proof on that. I may be wrong, and I would stand corrected of whether he made an offer of proof. But the fact of the matter is that his attorney apparently never filed a subpoena, or excuse me, served a subpoena on the police officers. They still had an hour and a half left of time for testimony on that day. This is a case that had been prolonged, and the judge, I submit, did not abuse discretion in denying the request for a continuance. These are police officers who were not present at the scene at the time that it happened. Their evidence would have been tenuous at best.
Counsel, I have a question. Do you have anything to tell us about whether there's any subsequent orders of the family court with regard to visitation, and whether or not that visitation has gone as 5 hours a week for this whole 18 months?
Okay. Well, another point of disagreement that I may have, and I can stand corrected, is that I think that the father had 6 hours of visitation, meeting with the child, and I have, of course. There's no problems with the visitation that has occurred from my interaction with the child and a brief conversation with the mother.
Further orders of the court?
I am unaware of any further orders of the court. My position on the idea of visitation is of increased visitation to have the usual kind of visitation is no. This is domestic violence. You don't get regular visitation when you have domestic violence that occurs in front of a child. So I think they would have to be restricted.
Can you earn more visit? He does have, I think it's 12:30 to 6:30. So I may have misspoke. My math isn't very good. So it is 6 hours, I think. But can he earn maybe not regular visitation, but can he earn more despite the domestic violence background? Is there anything in your view that can be done here for him to get overnight, a couple nights a week for dinner?
Yes, Your Honor. And it's called show up. This is a man who had, I believe, 5 different court orders, temporary orders of visitation. They're laid out in a chart on page 9 of my brief, in which he had visitation, supervised, public place visitation, various things, and he wasn't showing up. So when he's not showing up for 5 or 6 hours a week during the time that he is being scrutinized by the court, why should he have regular visitation afterward? So yes, I submit there could be a change of circumstances if he shows that there is ongoing good visitation occurring, but you have to go back to court on it, and you have to show up. So that would be my simple answer to that he has not merited getting longer visitation.
So up till the date of these orders that are being appealed from, but he may have in the intervening 18 months.
And that's great if he does.
Right.
A new AFC could evaluate whether it's appropriate for the child. But right now, during the time he was on trial, and there were several months going on, he had 5 different orders, and they changed each time, including going slightly higher and then going down because he failed to show up. One of the things, there's a presumption that visitation between a parent and the child is in the best interest of the child. But that presumption can be rebutted. And here, where you have one of the worst things that can happen to a child is to have sporadic visitation where the father or the mother does not show up. How disappointing that can be to a child. And I submit that it didn't happen here, and the judge was proper in restricting the amount of visitation.
All right, thank you, Counselor.
Thank you.
Ms. Jessie.
Good morning, Your Honors. My client, Giovanna, is not of the union. She's the older child here. There was no reason for her to have continued contact with Mr. Mack. The order of protection did expire, but it's my impression that there's no contact going forward. We support an affirmance.
Thank you. We'll now call case 921, Vito versus Dugan. 9:21. Good morning, Mr. Keen.
Good morning, Your Honor. Is the other attorney present?
We're waiting for him to join us virtually.
I'm sorry.
It's okay. Mr. Broderick is with us. Mr. Keen, you may begin.
Good morning. May it please the court, Brad Keeman, I represent Mr. Dugan. I'd like to focus on the supervised custody order here. Family court says 4 hours per week at times as the parties may agree. Well, in this case, these parties cannot agree. It is untenable to allow these parties to decide when supervised visitation can occur. The hearing testimony demonstrated that they argued often. One of the parties declined mediation at both April 11th and May 30th proceedings. You have allegations of harassing the father's mother, then the mother saying that there's berated her during a call with one of the children. Even the AFC suggested a third party, not the mother or father, determine when in-person parenting time could take place. Under these circumstances, we'd request that the matter be remitted for a more definitive in-person custody order so that the father can exercise his parental rights without being beholden to the mother's whims.
Mr. Keem, why would it be incorrect for us to sort of place the burden on your client to say, I've tried. I've tried to comply with this. I've reached out. I've set these hours. I offered this time. I offered that time. I need a modification because this order is not working now, as opposed to undoing it because we think that might be happening when we don't have any evidence of it.
Well, I think the case law is clear that when there's supervised visitation delegated to the parties, and the record demonstrates that that's untenable, that the family court errs in that regard. And that's what I think that this record demonstrates, that, sure, there could be another proceeding started by the father, but that's not what he's doing. He's exercising his right to appeal. And on this record, it's an untenable situation.
Do we know on the ground what's been happening? Have they been able to work things out? I know it's outside the record, but it goes to Noak's point. Why would maybe they've been working things out. Why would we upset that and send it back?
Well, Your Honor, in discussion with my client, and again, this is off the record, I don't believe that it has been worked out. And I would just ask the court to focus on the record that's available to it, and to find that this particular record demonstrates that it's an untenable situation.
The one thing it does provide, it provides a lot of flexibility. We're not going to set times, we're not going to set hours, we're not going to set any requirements. And your client's in Kentucky. So I would imagine that your client would have periods of time when he can come to Western New York, and then other times he can't. And so it would seem to me that the remedy does account for that. Is that something that we should give credit to the judge on, or is it still insufficient in your mind?
It still is insufficient, because in as much as I would agree that there's flexibility, when the record demonstrates that these two people cannot communicate with one another without, yelling and berating each other, I think that there's a possibility that the father has come back from Kentucky and wanted to see the children, but that has not been possible, right? That speaks, I think, again, these are off the record, but I mean, it speaks to why we assert that this order is insufficient considering the record.
We understand. Anything further that you want to argue?
Unless there are questions, we'll rely on our brief on our other issues.
Thank you, Mr. King. Mr. Broderick? You have to unmute yourself there. There you go. Not sure what's going on there. It sounds like a home invasion. Mr. Broderick, we can't hear you. We hear a lot of extraneous noise. I think it's at your end, and now we lost you. So at this point,
Not much.
we do fortunately have his brief. All right, we do have his brief, and we will deem it submitted at this point. His argument submitted. Thank you, Mr. King.
Thank you, Your Honor.
Case 925, Friends of St. Thomas, the town of the Wanda Court Zoning Board. Zoglin, good morning to you.
Morning. Hope everyone had a happy Thanksgiving. My name is Jacob Zoglin. May it please the court. I represent Friends of St. Thomas the Apostle, and I have a representative from the group in the courtroom with me today.
Welcome.
Thank you. We brought this action because the ZBA illegally granted a use variance for prohibited commercial and multifamily uses in an R1 district, which is intended for low-density residential uses like single-family homes. This is supposed to be a neighborhood. I've divided my argument into, yes.
So this is an old school building. I don't want to get you too much out of your organization, but this is an old school building. Hadn't been used in quite a while.
It was a piece of property that had three buildings. One of the buildings had been a school, and before that it had housed the original church in the basement. And then it had become daycares and used for those types of uses. So it had a long historical use as a school. That's correct, Your Honor.
Okay. And there was a desire to change the use from that to market rate apartments.
An application was made to convert the unoccupied building into multifamily apartments as well as commercial.
Okay. And that's what you're asking us to overturn.
Right. The variance that would allow high intensity uses like commercial and multifamily apartments in a residential single family R1 neighborhood.
So really your brief is focused on the dollars and cents proof or the lack thereof that the applicant submitted here to show that he could not get a reasonable rate of return on the uses that are currently permitted in the R1 district. So we got a church, we've got other permitted uses.
Yes, Your Honor. Church, school.
Start with the church, whether he can get a reasonable rate of return on the church. That seemed to be the strongest argument that the members of the zoning board, even those who voted in your client's favor, seemed to suggest that that was the only feasible, other reasonable use here. Do you want to address that one first?
Well, so there was a lot of discussion about whether a reasonable rate of return could be obtained for any permitted use. And as your Honor pointed out, church, school, and single family home rentals are the three ones that we've provided evidence in the record that they did not address. So to your Honor's point about the school, I'm sorry.
Yeah, the school. The school, yeah, for St. John Bosco, that seemed to be the only party interested here, and whether that was a realistic interest, whether there was any action on that interest since it was expressed.
So
that
yes,
it seems to be that is your argument that they should have pursued another school coming in, particularly the one from East Rochester.
Well, it's not about whether they should have pursued something or something else. It's about what that was in the record. Did the record show that they could not have obtained a reasonable rate of return if the property were used as a school? And one place we can look at first is the admission of the applicant. The applicant and frankly, respondents have stated no fewer than 3 times that I was able to identify, one of which was under oath before the ZBA, that a school use would be the highest and best use of the property. That
Because
is,
it would not require demolition. It would not require a lot of, it's a school right now, so it's cheaper to keep it as a school.
yeah.
It still costs a lot of money to renovate to a school, but it'd be cheaper.
Doesn't have to be a school that's willing to go there and wasn't that part of the problem? But that's just very speculative that, oh, we can find some school.
The question is not whether can they find a particular buyer for what they want. The question is whether the property could be used to generate a reasonable rate of return for any lawful use. And there's evidence that they've used this for daycares, for schools, and that a school was currently interested.
But you said it wasn't, but then you finished by saying it was. Because doesn't there have to be a realistic possibility that a school would use that building?
That is actually not the standard. The standard is whether the developer, the applicant, submitted dollars and cents proof, competent financial evidence to show that no reasonable rate of return could be obtained if it were used as a school for single family home rentals.
What if what if they're looking, I know the pastor testified at the ZBA hearing. Testified, we made all these efforts to try to find a school. The developer testified that he walked the representatives from St. John Bosco through, and there are no, it was on the market for a number of years before its condition had deteriorated. No school wanted it. Nobody wanted it. So they say, we can't get a reasonable rate of return unless somebody's willing to rent it or buy it from us.
So Your Honor points out that there's one issue that they've put evidence on the, would someone buy it? And there's some obvious issues there. You can lower the price. You can do a lot of things. You could change what you're willing to sell. But the important part here is that the dollars and cents proof standard requires credible evidence of all matters bearing upon the return. And it's significant here because there's one thing that they've pointed out, which is we tried to sell it and maybe they weren't able to at the price that they had proposed. But what is absent, noticeably absent, are what are called the dollars and cents proof, the competent financial evidence bearing on all matters. So what does that look like? What am I saying is missing? Well, the courts have given us some examples. They've said that market value of comparable single-family comparable uses is relevant. They've said that the annual income generated by prior occupants.
Wait a minute, but they did do this, we've been talking about a school use, so stick with that for a minute. Didn't they put market rents for a school use in their analysis? Didn't they give a whole range?
They
50 square foot up to $12 a foot. And you're saying it doesn't matter that a school wasn't, available or not, but they still used market rents for a school. And then they said, based on those market rents, we can't make money. Right? Isn't that what they said before the zoning board?
Your Honor references, I believe, the Stern letter, which is the only letter that tries to establish that type of proof and references only schools, doesn't do churches or single family rentals. But you're right. Yes. So to your point about what that letter does, that letter is the evidentiary equivalent of a billboard. It's hearsay. It's all conclusory. It doesn't disclose or provide the underlying data, where it came from.
But how does that fit in with our requirement here? We can only look at substantial evidence, right?
Absolutely. It fits into what your job is because the courts have held not only that substantial evidence standards apply, but that a substantial degree of proof, they call it a substantial quantum of proof, needs to be presented. And they've identified exactly the type of proof that constitutes competent financial evidence or dollars and cents proof. And it's not just were they able to get a buyer. It's questions about the credibility of the dollars and cents proof, what actual numbers were in there. For example, was the annual income generated by prior occupants? These things help us tell what a reasonable rate of return would be, which was never identified, and whether they could reach that number. So I want to return to that idea that the courts have said, and this is under Village of Fayette v. Gerald, that before an applicant can even prove that a property cannot yield a reasonable rate of return, the applicant must first ascertain what a reasonable rate of return would be. That makes perfect sense, right? Because if you're going to say that's not enough, the next question is, well, what would be enough? And they've never answered that question, what would be enough for a reasonable rate of return? And that's an error as a matter of law. By contrast, we do have substantial evidence in the record from the Crane report that provides dollars and cents evidence both on the school issue, the house of worship issue, and on the single family home rental issue. The single family home rental issue was never addressed by the Stern letter. And frankly, the only evidence in the record on the rental of single family homes comes from the Crane report. So
wasn't there sworn testimony, Mr. Barrett, at the hearing, and some evidence that to demolish the school would cost in excess of $1 million? There's some analysis, you get 2 lots out of that. It's just not economically feasible to tear down the school, which a lot of people value. That structure's been up since 1922, and it would preserve that. There was some analysis of the cost with destroying the building, having everything hauled away and starting from scratch. Mr. Barrett did some numbers there. I don't know, I guess you're suggesting maybe he should have submitted those in writing?
Well, he should have submitted them in writing, absolutely. But the real issue here is that whole concept is legally wrong, that it could only support 2 houses. If you look at that property.
How many houses do you think the church, if it's demolished with the parking lot area, how many single family residents could be built?
Well, I'll give you the numbers and I'll tell you what my math is. The property size is 270,000 square feet. The minimum lot size under the code is 9,600.
When you say property, you're talking about the school or the whole complex?
The whole complex. The school has not been subdivided yet, so you can't talk about subdividing it differently unless you talk about what maximizing it.
Most of the opponents who spoke at that public hearing want to preserve the church, this parish. What you're talking about is knocking down everything, the church and the school, and building houses there. That's not consistent even with your client's position that they want to preserve this parish.
The question is what the legal standard is and whether they met it. And so frankly, if you do the simple math, that you have a 270,000 square foot property, the minimum lot size is under 10,000. Even if you make it 10,000, that's still at least 27 lots. So there are
27 lots if you tear down the church too.
Well, I mean, they haven't subdivided it.
How many if you just demolish the school? How many single family residences can you build there?
Well, it depends on where you draw the line. The property has never been subdivided, so you could draw the line out further and you could subdivide it and you could generate a lot more than
take away parking from the church. There already seems to be a problem, people parking on the street, but they say 2 houses, you say 3, 4, 5.
The problem is they didn't put substantial evidence in the record to substantiate their claim that they could do 2, and the math does not work.
So they didn't meet their burden in your view?
They didn't meet their burden, and that's on the error of law regarding the subdivision. There's another error of law.
Counselor, you talk about maybe 27 houses. How does that change the density? They're talking about 25 apartments. You're talking about 25 houses.
Well,
what you're talking about is far denser than what they're talking about.
I'm not proposing doing, whatever. I'm not going to make a project. But to your point, it would be less dense if you have single family homes spread out over more space than if you had a lot of single multifamily apartments in an apartment on a less square footage with commercial on the bottom. It's denser because you have more people and less space, and it's more intense because you're attracting people to the area that would not otherwise come there. Commercial uses generally generate traffic all throughout a day. So, and this is a residential district.
Unlike a school and a church that attracts people at all sorts of times a day, which is the use you're advocating.
I'm not advocating. I'm saying they need to demonstrate that they cannot get a reasonable return if they do a permitted use.
Right.
That's all they need to show.
Client's position, they don't want anything built. They don't want anything changed. They want the parish to remain. They want the abandoned school to be abandoned unless some school out of nowhere decides to come in and rent it at some exorbitant cost. That's what they don't want to, just to be clear, they don't want they don't want single family housing. This is an argument to say that the applicant hasn't met their burden of proof.
The
So
applicant
would not get a rate of return if they did something your clients don't even want them to do.
Well, we are not saying that they should do this. I mean, I
Right.
think they would like to see the building and the structure and everything preserved and used by the church. But that's not really the legal issue, and that's not the issue that is before the court. But there's another issue that I wanted to highlight, which was that the ZBA essentially erred further by concluding that the property could not yield a reasonable rate of return if used consistently with its historical use as a school. But the record really does not support that decision. It demonstrates that 3 different examples of the applicant admitting that the school use is the highest and best use, including under oath before the ZBA, in writing, and even in writing to this court.
Right. I read that to mean, and maybe I'm wrong, I read that to mean, interpreted it to mean that if a church were willing to, I'm sorry, if a school were willing to come into the school, that would be the best use because it's less cost to convert it because it's already a school. I interpreted their argument as being, but we can't, no schools are interested. The only one that had interest is the St. John Bosco, and there was a walkthrough, they discussed numbers.
And
Bosco pays $30,000 a year, I think, on their mortgage, and now they're talking about hundreds of thousands of dollars across town. It just didn't seem feasible.
And I understand if your honor is concerned about the school use, but undeniably so if you don't mind me moving on to single family home rentals, is that the Crane report was the only professional expert evidence provided that spoke to single family home rentals. When the developer complained that wasn't gonna yield, that single family wouldn't yield a reasonable rate of return, they're mostly talking about sales.
Right, you're talking about rentals. Was there any, can you point me in the Crane report to where demolition costs are taken into account?
I would have to take a look more closely at the report, but her report is at 150. And I'll even if you take that into consideration, those costs were, the costs related to the structure are only there because the property owner failed to maintain it.
That gets us to the last issue if the hardship is self-created, but does Crane says you can make money by renting houses. Mr. Barrett says, no, you can't, because I would have to sink in $1 million to demolish the school. And then all these other construction costs, it's going to be the houses based on his math to be about $800,000 a house. And that's who's going to buy that in Irondequoit.
My recollection of the Crane report is that it relied, and it stated that it relied on evidence that professionals in that field rely on in performing a professional opinion, that it reached its opinion to a reasonable degree of professional and expert certainty. All assertions that were not made by the Stern report, by any expert representing the developer.
You're saying somewhere in the Crane report, Ms. Crane looked at it and said, it's going to cost X number of dollars to demolish this building. There's asbestos, there's lead paint, and she factored that in to her calculations?
My understanding is that she stated that she relied on evidence provided in the record, and so that the evidence that was provided by the applicant was incorporated into her analysis. I know there are 2 other issues that Your Honor had mentioned I wanted to touch on briefly. One is how the use variance will affect the essential character of the neighborhood. Courts have found that traffic impacts such as these things that alter the essential character, they alter the essential character of the neighborhood. And the critical point is not comparing it to what an other use could be. It's not about comparing this to potential other single family uses or school uses or whatever. It's about comparing the proposed use, the multifamily apartments commercial, against the current use, which is
it's not being used.
You have to compare it to the current use, not to a hypothetical different situation.
A current use or a current vacant use?
Right.
It is currently vacant, correct? It's being used for parking, right? So you can't engage in a hypothetical. You have to deal with the facts on the ground when you're doing the use variance analysis.
But any use is going to change the character of a vacant parcel.
So you have to at least consider it. How much is it changing it?
And you're saying they didn't consider that?
They did not. No, they were making the kind of apples and oranges comparison here. It's also important to note that the appellate division has held that the introduction of commercial uses into a residential neighborhood introduces a commercial atmosphere and therefore changes the essential character. We saw that in Rosalie Associates v. Melkin, second department case.
The commercial here is a Starbucks within the proposed apartment complex?
The entire first floor, I think, is supposed to be commercial. So that's a lot of square footage.
That's because there's tax advantages for that. For mixed use.
Oh, you're making a joke, or you're.
That's true, though.
Is that what that you think that's why they're going for it?
I can answer that question. And not that it doesn't matter.
I wouldn't want to speculate.
It's semi.
Yeah.
Sorry.
No, that's all right. But it's not really in serious dispute that this is going to be denser and more intensive than current. Also, I want to point out that respondents admitted on page 25 of their brief that the use variance application is inconsistent with prevailing patterns of development. They've also admitted that it's inconsistent with a comprehensive plan. So the fact that you have a town code and a comprehensive plan where they've admitted it's inconsistent and it's inconsistent with prevailing patterns of development go on to show us that this is going to change the character of the neighborhood.
I think your clients have a fear, not unreasonable, that if commercial is introduced, mixed use commercial, it's one thing to say a Starbucks within the apartment complex, but then we get to a gas station, we get to 7-Eleven, we get to other things down the road. Once that door is open, it's kind of hard to close it. I think that's a reasonable fear that your clients have.
And absolutely, and the town, when it drafted the zoning code, didn't want those things. That's why it said that they're prohibited. Any use not allowed is prohibited. So commercial and those higher density residential are prohibited. And not only did they initially prohibit them, they had opportunities to reconsider it. There was an application to the town board to rezone. There was that goes to the planning board for recommendation. The planning board recommends denying the rezoning to allow that type of use. The town board also rejects it. In their briefs, they claim we didn't raise that. That's not true. Exhibits 3 and 4 of the petition raise that, which are also pages 112 through 123 of the record.
If you could close on the self-imposed hardship issue, it seems to come down to whether the church's neglect of the school caused the hardship or whether the vacancy then caused the neglect that caused the property to deteriorate. Which came first, the neglect or the vacancy?
I think they came together, right? So and I don't think it's in the record which came first, but the land property owner has a policy, and the policy says keep the heat on, right? I'm simplifying, but they have a policy. They ignored it, and very predictably, as a result of turning off the heat, you run into all sorts of things like issues with pipes and deterioration of the building.
Is there some concern, safety concern with the boiler? I know somebody come in and they caused some damage to the boiler and some safety concerns with keeping that on when you have trespassers on the property. Is there something in the record about
whether they had maintained it? Yeah,
the church is obviously concerned about costs. Is that we can't get any money out of this school. Money is tight, and our membership is declining. Why would we spend all this money to keep this property in a good condition when nobody's wanted it? It's been on the market for years and nobody's wanted it. But there was also seemed to be a safety component maybe with the boiler.
And I think Your Honor hit on exactly the point that the ZBA chair hit on, which is why weren't they, cited for violations and forced to make it safe, which is what you do with any other person that violates the zoning code. And he said it, best, which is, I'm going to see if I can get his words verbatim, something along the lines of, what I see as a problem here is that this property was allowed to go to seed for more than a decade, and that now they're coming to the ZBA to ask them to fix the problem they created. I mean, I'm paraphrasing.
Is the problem though? I don't think the problem is necessarily that it's gone to seed, but it's vacant. Even if it were maintained at a tremendous cost to the church, there's not a reasonable rate of return right now.
Well, people
because haven't been able to sell it, haven't been able to rent it. But that's an important issue, whether it's self-created. And I think Mr. Hinman got 2 votes on that, 2 out of 6.
And frankly, they've conceded that they stopped heating it, they stopped maintaining it, and they said in some of their papers that they submitted that part of the reason that it became so deteriorated is because they stopped taking care of it. So, I mean, the whole idea.
You're saying it's self-created because it was vacant for 10, that's not why the school left, because they didn't maintain it. It was after it was vacant. So what you're basically saying is to keep its use as a church, as a school, excuse me, it required an additional investment that they wouldn't have otherwise had to make, but for the property.
Is the investment you're talking about, Your Honor, the investment of keeping the property safe?
Boiler and safe and to a.
You're right that it does cost money to keep things safe, but the New York State Building Code already requires people to keep things safe. And the town's failure to enforce safety codes against this owner, and then the owner allowing it to become unsafe, does not then create a right to use the property in a way that is prohibited by the code.
Right, but saying it another way, you're saying that that's what created, that's your argument for the self-created hardship, that they didn't maintain it, so therefore it made it more expensive to rent as a school to somebody else.
And
not feasible.
And their alleged cost to repair and make it usable. I mean, they have not said what the cost would be if they, didn't allow this property to go to seed for over a decade. And they've made an argument in their brief, a legal argument that I believe is incorrect. They say that it's only when you essentially come to the non-conforming issue that it's a self-created hardship. That's simply not true. And we've cited examples of boards of standards and appeals doing the same thing.
Thank you also.
And so I know that I'm pretty much at time. So unless there are questions from the bench, we'll rest on our submissions.
Thank you.
Thank you.
Mr. Ferrante now.
Morning, Your Honors. Eric Ferrante, Nixon Peabody LLP, on behalf of Town of Arundecoit Zoning Board of Appeals. I'm also arguing this morning on behalf of the other respondents in this case.
Is there proof in the record about dollars and cents?
There is, Your Honor. So the developer in this case, 43 North Real Estate, submitted a detailed letter that explained a letter from the developer. There's 2 letters in this case, a letter from the developer and a letter from Fiore Stern, that both of which include an explanation, a narrative regarding the financial condition of the property and what it would take to redevelop the property into a school, or to, I suppose, renovate the property so they could be used as a school. And then the 43 North letter is backed up by financial data, by a pro forma performed by 43 North that shows that the total upfront capital investment required to bring the school into conformity with New York State Department of Education standards would be approximately $1.5 million.
Is there any indication what percentage of that 1.5 million would be required, even if the property had been maintained over the years? It's an old property. The school hasn't been in there in 30 years. There's daycare in there, I know, but it hadn't been used as a school for.
It's been a significant period of time since it's been used as a school.
So I would assume there's going to be if a school wants to come in now, there's going to be a lot of renovation costs associated with it. Any breakdown of what percentage of that number is due to neglect?
There is not, Your Honor. There is, however, so some of the things that they note in, I believe it's in the 43 North letter, it may be in the Fiore Stern letter, regarding some of the things that the school is lacking that would be required or that schools are looking for in modern educational buildings are larger gymnasiums than the school currently has, or this building currently has, and outdoor fields. And so that is part of the cost that would be required to bring the school into compliance with Department of Education requirements. I think there's also, I mean, there's likely lead paint in the building. There are things that, right, there would be significant remediation efforts that would be
Asbestos.
required regardless of the condition that the property is in today. So the financials also show that there would be, in addition to the 1.5 million that I noted, an additional $1.5 million in debt would have to be taken on for a total project cost in excess of $3 million. The financial analysis performed by 43 North also showed that over a 10-year pro forma period, it would cost about $2.7 million in operating costs to keep the building maintained and running as a school, and using the market rate of rent that was provided by Fiore Stern of $7.50 to $12 a square foot. The building would generate about $1.2 million in negative cash flow over a 10-year period. So it would operate at a loss.
Okay, did the court consider the change in the nature of the neighborhood by adding this construction to it?
The ZBA did consider the character of the neighborhood. So I think a couple points on that. The first is, so this project, what it's seeking to do, just to give some context, is, as Mr. Zogla noted, this is a larger parcel. And it's part of a larger complex. There's the church building, there's the school building, there's a rectory. If this project were to go forward, the school parcel that holds the school would be subdivided out, become its own lot. The school, the structure itself would remain. It's really the interior where the majority of the work would be done to convert it into apartments. And the ZBA considered that use. They looked at the fact that the neighborhood is residential. What's being requested to be put in the building would be largely residential, and they concluded that would not be represent a significant change in the character of the neighborhood. Now, in their briefs, the petitioners claim that the ZBA actually said, well, this would be a change in the neighborhood, a change for the best, or a change for the better. That's not what the ZBA said. What the ZBA actually said was having this project in the property would be an added benefit to the neighborhood. They use that term, added benefit, but that it would not change the character of the neighborhood. And so that's how they concluded.
The brief is replete with arguments that the applicant didn't submit dollars and cents proof. Every other page of the brief. Is there an exception to that where if certain expenses are so obvious, I think there's some principle of law, if it's reasonable, you can use a reasonable business judgment. Some things you don't need dollars and cents proof for. You can just use common sense on it. Do I have that right? Is that the legal principle?
I believe so. I have not seen that used in the context of these cases. What I would say, though, Your Honor, is we've been focused on.
I believe Mr. Barrett spoke to that at the public hearing.
Mr. Barrett, so he noted, and I mean, I think we've pointed to it in our brief. He noted all the different areas of dollars and cents proof, and he provided even more during the hearing. I think what he may have been speaking to, and what I think really, if we were to put the applicant and the town through the paces on these uses, it would be just a totally futile effort. Is we've been focused on the school use, the single family rentals, and the church use. There are other allowable uses in this R1 residential district, things like a public hospital, fire station, municipal building, public libraries, those sorts of things, where it's just obvious that this property cannot be, it's not owned by the public. The public has had, the town of Arundecote has shown no interest in building an additional municipal building in this neighborhood, or really for that matter, anywhere near there. And so to require dollars and cents proof to show I can't realize a reasonable rate of return on a use that I can't reasonably, or the current owner can't reasonably put the property to use as, I think that would be a bridge too far. That would be requiring everyone to sort of just go through the motions for the sake of going through the motions with no real sort of logic or reason or justification for requiring them to do that.
Seems like the petitioner's best argument is the one that the chairman agreed with, Mr. Hinman, at the hearing, that this was self-created, not by the developer, but by the church, by neglecting the school for all these many years. And that's why he voted against it. What's your argument there that it's not self-created? Because it was clearly neglected. They knew that the boiler wasn't working and they made a financial decision. We're not going to fix the boiler. We're not going to have any heat there. Without the heat, that led to all these other problems.
Right.
Not a terribly unreasonable argument.
So a couple of points. First, I think on the boiler issue, there's a letter from Father Gagno from the parish that notes that the reason the boiler was turned off is because there was safety concerns, I think, as Your Honor noted earlier. Folks breaking in the building, lighting fires, vandalizing, things along those nature.
They wanted to turn the boiler off so there's no gas that could ignite.
So that's my understanding. I don't represent the parish, but that from the letter, that's my understanding. So I think there was a justification for that. But be that as it may, I think the focus on the deteriorating nature of the property, it's a focus on the wrong issue. The reason that there is this is not a self-created hardship, or the hardship that exists here exists just by virtue of the fact that this is a 36,000 square foot brick building in the middle of a residential neighborhood. There are only so many things that you can use a building of that size for, deteriorated or not. And so the hardship is created just by the existence of this unique structure in this neighborhood.
Even if it were in pristine condition, there could be a hardship here because no other school wants to move in and nobody wants to buy it.
That's correct, Your Honor. Yes. It's been on the market for 10 years.
Did you say 10 years?
Sorry?
Did you say 10 years?
It's been on the market for at least 10 years, I believe, is what the evidence shows, yes. And so it's the nature of the building, of the property itself. It's unique in this neighborhood. It can only be used for so many things feasibly and economically. And so that's the hardship. Sure, the fact that it's deteriorated maybe has contributed to that, but the hardship in our eyes is created just by the presence and nature of the structure that is on the property here.
Your time is running short, but one last issue that did catch my eye from the hearing was a representative of St. John Bosco Church showed up at the hearing and that we want to rent here. We want to buy it. We want to have a school here. And that was not, there seemed to be no interest in working with them any further on that from the developer's viewpoint. How is that not, you have somebody right then and there at the hearing saying, we want this.
Right.
How is that not a reasonable possibility to get a reasonable rate of return?
Sure. I think a couple of things. First, anybody can show up and say, I want this building, right? But when you get down to the nuts and bolts and crunching the numbers, that may change your view of things. And here, I don't think it's accurate to say that the developer just showed no interest in working with the property. In fact, there's evidence in the record that the developer met with St. John Bosco.
Yeah.
They discussed financials. He offered to fund certain improvements at the property, walk through what a reasonable rent would be. And then with that information, St. John Bosco said, this just doesn't work financially for us. And so we are not, in fact, going to move forward.
Yeah, St. John Bosco may have wanted it, but the question is at what cost? It sounded like they contacted the diocese, they wanted it for a song and might not have wanted it for what would have provided a reasonable rate of return. Two different things.
I think that's fair. Yeah.
All right.
All right. With that, I will rest my briefs. Thank you very much.
Thank you. Case number 928 is Wycheck versus Miller.
Thank you very much.
Okay.
Thanks, Mark. That's good for you.
Good morning, Your Honors. May it please the court. Brittany Pemerthy appearing on behalf of plaintiff appellant. Injured in a car accident of October 26, 2021, entirely caused by the fault of the defendant respondent. If I may begin there, defendant makes no legitimate argument against negligence in this case, and the lower court failed in rendering liability in favor of the plaintiff on that matter. Here, the respondent defendant blindly left a parking lot, not seeing traffic in her intended lane. She relied mistakenly, as she put it, on instinct and someone else waving her on, ultimately striking the plaintiff and causing serious injuries. Plaintiff never left her lane and was traveling properly within her lane. Defendant was thus the sole proximate cause of the accident herein.
Can I just offer this as a suggestion? I thought that possibly the court didn't reach the negligence issue because the threshold issue was,
Right, it would have been mooted by the decision.
that's right.
Right.
So, maybe the court would have got there had they made a different decision on the injuries, but didn't need to.
I don't disagree. That's probably the court's conclusions. Nonetheless, obviously, I want to preserve the matter here for this court. So moving on that as well, respectfully. Turning obviously to the crux of the matter here, defendant was the initial movement relative to the summary judgment motion. So they initially moved, suggesting that plaintiff did not meet the serious injury threshold here, despite failing, I would argue, to even meet their initial burden. I would submit, relying on Rivers versus Burbom, which is, I know, a second department case, albeit the blanket assertion that Dr. Cambreri is simply a New York licensed physician is insufficient. I don't think that's enough for a court, especially this court, to suggest that he is qualified to render an opinion relative to plaintiff's cervical, thoracic, or right shoulder injuries. We simply don't know what area of medicine he's qualified to opine.
Was that, and it probably is, it's my fault, but I didn't see that argument being made, his qualifications.
It was made in my moving papers, Your Honor. Yes, I did address.
In the brief?
In the brief, yes, Your Honor.
All right, thank you. What page is that on? That's fine. I don't want to waste your time with my mistake, but you may proceed.
Thank you, Your Honor. I will attempt to find that.
I'll find it. But in any event, so the defendant didn't meet their initial burden. He's not qualified, Dr. Cambreri. In any event,
I would submit even
raise an issue of fact in your view, if we
even attempting to put that aside, Your Honor, that in fact, he's not qualified to render any opinions relative to this matter. Further addressing just the crux of his report itself, Dr. Cambreri makes no reference whatsoever to the individual categories of Insurance Law 5102. But most importantly, here in this argument, is that he never opines when appellant's injuries were allegedly resolved. Dr. Cambreri ultimately diagnoses from the accident, so he gives a causal relationship, saying that the plaintiff has a resolved cervical sprain and resolved right shoulder pain at most contusion. However, he concludes this 2 years post-accident with no mention whatsoever of the 9180 period and no mention whatsoever of when these injuries are in fact allegedly resolved. Respondent has not in fact submitted any evidence by which the lower court could rely that would suggest minimally plaintiff failed to meet the significant injury or 9180 category. Resting, of course, on Your Honor's previous decision of Gone versus Senseo Health, this is just simply insufficient.
Why is your testimony insufficient? Going back to work, not missing any work, et cetera, describing your activities, why isn't that sufficient?
Well, it's not insufficient relative to the significant limitation. She in fact says that.
No, on the 9180, only on the 91.
Well, I would submit actually that her testimony supports 9180. While she, of course, never missed time from work, and I'm not suggesting she did, you don't have to necessarily miss time from work to have a 9180 qualifying injury. In fact, you just have to have injuries that limit your daily living activities. She said, in fact, her work was impacted. She wasn't able to engage in work the same as she was pre-accident. Specifically, I think she described, obviously, being able to interact in the school resources that she does. She talked about relative to her newborn child, the impact that had on caring for her newborn child. She talked about her sleep disturbances. She talked about just her daily activities, cleaning, cooking, things like that. So I would in fact submit that her testimony alone is enough to support the 9180 category. And I certainly would submit that there was never any sufficient evidence submitted by respondent in this case to warrant summary judgment. Lastly, relative to the arguments raised by respondent defendant, there are no records whatsoever within this record or however that existed relative to or predating the subject accident. So it is thus completely conclusory for the lower court or for defense counsel to suggest that this was the cause of her injuries. Most significantly, there's absolutely no mention whatsoever of any previous injury to her right shoulder. So I would submit that when a defense doctor, Dr. Cambreri, and obviously the treating physician, Dr. Rubicha, is submitting here that there's a causally related injury to her right shoulder from this accident, that alone suffices, and that certainly respondent could not be awarded summary judgment relative to this case. At worst, I think the competing, obviously, opinion of Dr. Rubicha, plaintiff's treating physician, is a question of fact for the jury. Turning, however, to appellant's cross motion for summary judgment, we would submit obviously that the medical records, the affidavit of Dr. Rubichaw, and appellant's own testimony meets the level of qualifying serious injury warranting summary judgment in plaintiff's favor. Dr. Rubichaw has submitted an expert affidavit opining plaintiff suffered from a rotator cuff sprain with post-traumatic rotator cuff tendonitis impingement syndrome of the right shoulder, using not only an interpretation of an MRI, his own interpretation, but also physical exam of the plaintiff appellant, noting positive orthopedic findings which have not been rebutted, tenderness and limitation.
The fact that she didn't seek treatment for a year and a half after.
Well, I
She
think
had a pre-existing condition.
Thank you, Your Honor. I think that's actually a mischaracterization. First off, there's no suggestion that there's a previous injury to her right shoulder whatsoever in the record. With relative to the suggestion that she never treated specific to her right shoulder, I would disagree. In fact, at the ER, she reports of complaints of her shoulder. The chiro records immediately following the accident indicate complaints of the right shoulder. Dr. Rubichaw highlighted in his affidavit that pathology related to the cervical spine can mimic pain in the shoulder, and the injuries to these two areas impact one another. So that's within the record, the record at 256. So simply, there was no also gap in treatment here. You know, she presents to the ER, she follows up immediately with a chiropractor, she continues with that chiropractor for 7 months. The chiropractor eventually opines in his medical opinion, okay, we're going to continue on a course of at-home exercises. She complies with that. And he notes, if matters get worse though, I want you to return. She does exactly that. You know, the matters got worse, and three months after that, she returned to a chiropractor, albeit a different chiropractor. Now she begins treating with that chiropractor, who then opines, you know what, it's necessary that she gets referred on to an orthopedic, and does just that. And she, again, complies with the orthopedic referral, presents to Dr. Rubichaw, Pinnacle Orthopedics, is then referred out to physical therapy. 2 years post-accident, she has treating physicians saying that treatment for the injuries she sustained in the accident are necessary. 2 years post-accident. We would submit that's more than sufficient to render a finding in favor of significant limitation relative to this accident.
Why doesn't Dr. Camberry's report create an issue of fact with respect to the shoulder? Well, he says, I'm looking at the MRI and I just don't see it. I don't see the tear. I don't see same types of things.
I would submit we don't have to have a tear for there to be a significant limitation to her shoulder.
It's not what he says either. He's saying, I don't see anything. He says unremarkable.
No,
looking at 202 of the record.
Yeah, he in fact says that she has a resolved right shoulder pain, at most contusion. That's what he opines. When he's talking about diagnosis, a little bit above that paragraph, I think Your Honor's referencing, he opines related to this car accident, she has a right shoulder pain that has resolved, at most a contusion. So at most, he's conceding there's a contusion related to the car accident. So he in fact finds
It is not a serious injury, is it?
I would argue if it's coupled with the limitations of her activities as she testifies there too, it is. And I would note too that again, falling back on the faults of the defense IME, there's simply no indication anywhere in that IME that there is a period of which this resolve occurred. You know, while it's saying it resolved, it doesn't say when.
Her usual and daily activities, her testimony, as I recall at her deposition, what can you not do now that you used to be able to do? Well, rearranging things in the cupboards. Wasn't a whole lot there. Maybe playing outside, throwing a ball with the kid. Doesn't it have to be more than that? A substantial number of your usual daily activities. Didn't seem, compared to other cases we have on 9180, her things that she couldn't do were much more limited than what we usually see.
I would submit that her testimony was in fact sufficient, Your Honor. I think that she testified not only to the impact it had on her work and what she was able to do at the school, but also I think significantly for a mother with a newborn is that she couldn't properly care for her newborn without the injuries from the subject accident impacting that. You know, she went on to talk about other varying things. Again, the sleep disturbances, the cooking, the cleaning, lifting, things of that sort. But I think that's sufficient. And to go back to Your Honor's previous request, brief page 18 talks about the issues relative to qualifications of the expert.
Are there any objective measurements in either of your affidavits
Well, I would submit that there were objective findings relative to orthopedic testing, limitations relative to the right shoulder. Moreover, in the chiropractic records, at least initially, it notes the range of motion limitations of at least 4 different categories of at least 25% limitation.
And that's in your doctor's medical affidavit.
Correct.
And
correct.
what about theirs?
Relative to Dr. Cambreri's records, he, again, 2 years post-accident, does note some limitations. I think it was of 15% approximately. But without the record before me, Your Honor, I don't want to be quoted on that.
Is it enough, assuming that the defendant has no initial burden on the shoulder injury, for your expert to say that there's some motion artifact of the that appears to show a partial tear, rather than there is a partial tear?
I know defense argues that this interpretation of the MRI should completely negate the finding of the expert, but I would disagree, Your Honor. The expert doesn't need an MRI to find the opinion he has relative to impingement. He can do that on the orthopedic testing he performed, and he notes in his records that all those orthopedic testing he performed relative to impingement, that being humans and speeds, et cetera, those were positive findings. Those positive findings substantiated his need for an MRI. He gets the MRI, he interprets the MRI, he says, yeah, it appears exactly what I thought. There was this impingement. So I think it's not even necessary to consider this MRI. So if Your Honor's concerned about the wording of appears, we don't even need that. It's enough that he has conducted positive orthopedic findings of the right shoulder prior to doing the MRI interpretation. He gets the MRI, interprets the MRI, and then still opines the exact same injuries relative to plaintiff. And with that, I would just submit, I think that we've certainly satisfied our requirement that the complaint be reinstated, and we further request that this court consider granting summary judgment in favor of appellant relative to negligence and serious injury. Thank you.
Thank you.
Good afternoon, Your Honors. May it please the court, Kevin Graff on behalf of the defendants. Certainly, it's our position, but the lower court properly granted our motion. It relied on not only our experts' report, which is a doctor who's routinely used to support motions.
Okay, so let's go to that subject. Opposing counsel says you haven't demonstrated your examining physician's qualifications to do this kind of exam in the state of New York. What do you say?
His report states he's a doctor licensed to practice medicine in the state of New York. I don't know what other.
She says more is needed than that.
I disagree with that. I feel if he's a doctor licensed to practice medicine, that's.
Is it supposed to be specialized to this particular injury or just a doctor?
Well, I mean, he is an orthopedic surgeon, and I apologize, I don't have the copy of his report right in front of me. But like he is certainly a doctor who opines on orthopedic injuries to the spine and shoulder on a regular basis in the courts in New York. He's testified in the courts in New York.
No, we know that, but are we allowed to consider that?
Absolutely. I feel his report lays that out, like that he's a doctor licensed to practice law, and I feel it's my argument that is sufficient.
Because if you lose on that, then.
Well, correct.
We don't go much farther.
Right, no, but it's the report that he lays out his license, that he's licensed to practice medicine, and I feel that is sufficient.
We'll take a look at that one.
And then I also feel that in addition to his report, we also have the testimony of the plaintiff herself and the record for medical, which support our position that there's no threshold injury. And I think it's.
Why do you say that? I mean, you have, I see in Dr. Cambreri's report, no objective evidence of any permanent structural injury to the cervical spine. We have the significant limitation of use category. We have 1.5 years of treatment, at least in terms of the chiropractic treatment, all those visits, where every visit we're seeing a reduction in flexion, extension, all of these ranges of motion, every visit with pain, without pain, documented. And I don't see Dr. Cambreri addressing any of that treatment, any of those values or anything else, other than mentioning that he saw the records. He doesn't say what that was. He doesn't say that's related to degeneration. That's related to something else. That's related to the work injury 10 years ago. He doesn't do any of that.
Right.
And so the question is, if Dr. Cambreri doesn't comment on it, how do you meet your burden on just that category?
Well, it's my argument, Your Honor, that it just simply him finding that there's no structural injury to the cervical spine. There's no MRI of the cervical spine in this case. We have a CT done at the emergency room, which showed degeneration. He reads that, he finds that there's degenerative changes. We know about the priors, and based upon that, he's finding that there's no injury to the cervical spine in this case. So it's based upon the prior, and admittedly, the prior records are not available. We don't have those, but the plaintiff testified to them, and the records, some of the forms she filled out acknowledge the prior. So we know about the priors, and he reads the CT scan, and he finds that there's just no objective injury to the cervical spine in this case.
Right, but in terms of trying to say, well, her treatment was related to this work accident or something that she had in the past because she had prior chiropractic treatment, it struck me from the papers that that came from you as the attorney and then not from a medical provider. And I suspect that, you say, well, the plaintiff at some point has to show that it wasn't related, maybe, but this is your motion, so.
Yeah, no, and I just feel that his opinion does address all that, and he reviews all the materials of the notes of the prior treatment and then what was the treatment after, and in addition to a 3-month gap in treatment in the chiropractic, and he just comes to the opinion that there's not an injury to the cervical spine here, and which is the basis obviously for his opinion and his report that there's no threshold injury. And we feel, I
understand the point.
Yeah.
But it strikes me more as, well, we don't have film. We don't have film showing that the specific injury. We have all this treatment though. And it seems to me that doesn't seem that Dr. Kemmer is claiming that your client is getting medical treatment she doesn't need. Claiming that she's faking it, malingering. No, I don't see anything like that in the record.
No, but I
don't see him attributing it to something different, the past or something else. I'm trying to get a sense as to whether you have to do that or whether you can sort of leave it in the feather.
He doesn't, he obviously reads her deposition transcript and looks at her records, and he knows that there is the prior treatment as well. So he is
could have said it.
he is stating that he's opining on what this accident caused, and he's saying that with everything in front of him that there is no cervical spine injury in this accident. So, but we feel we've met our burden. In opposition, we feel that the plaintiff has not raised a question of fact, and once we meet our burden with respect to the cervical spine issues, again, no, we don't have the records, but there's just nothing submitted. The only affidavit submitted by plaintiff in this case is regarding the shoulder. There's no affidavit on the cervical spine. So there's no opinion at all from the plaintiff that comparing like her pre-existing treatment to her post-accident treatment. So we just feel the court was proper in granting the motion on the cervical spine. And then with the shoulder, these have been touched on, obviously, the reading of the MRI report. We have a radiologist who reads it as unremarkable. Dr. Cambereri reads it as normal. And then we have Dr. Rubacha, who equivocates and says, well, possible tear. And obviously the lower court didn't find that sufficient for an objective injury. I would note that in Dr. Rubacha's reports that he repeatedly, even though he finds a possible tear, he repeatedly finds she has no disability. At every visit she goes to, Dr. Rubacha says she has no disability. And after a brief course of physical therapy, she goes back to him and says, I don't need to treat anymore. So we just feel that there has not been sufficient evidence to create a question of fact on that issue.
One more question.
Yeah.
And that's what counsel led off with her thoughts on summary judgment on the negligence and causation of the car accident itself.
I agree with Your Honor that the lower court judge did not get to it because he granted the threshold motion.
Okay.
I have no argument in opposition to the negligence aspects of the motion.
Okay, very good.
Okay. Thank you. Thank you.
Case 930, Van Buren Farms LLC versus Hendricks Farms.
Good afternoon, Your Honors.
Good afternoon. We're going to give opposing counsel a moment to get settled on the screen.
Absolutely. He's already demonstrated he's much smarter than I am by appearing virtually instead of driving in from Buffalo.
Counsel is with us now. So, Ms. Alec, you may proceed.
All right, may it please the court. I'm Preston Zarlock, Phillips Lytle for the defendant appellant Conklin. Conklin's a manufacturer of fertilizer products, so I'm sure the court's read everything, so I'll be brief on this. The plaintiffs allege they bought fertilizer products from defendant Hendricks, that the products were applied by defendant Acme, and that it caused damage, loss of the hay crop, and related reputational damages, essentially. After amending this complaint once in response to our initial motion to dismiss, they alleged only a strict products liability claim against my client, purportedly in manufacturing design defect, seeking only these economic damages. There's no personal injury involved here. And my motion to dismiss was denied for 3 reasons, each of which I think was incorrect. The first one is that plaintiff has not pleaded a design defect or manufacturing defect claim with the specificity required by this court. I cite to Soule, S-O-U-L-E versus Norton, 299 82nd 827. That's at my brief at 16 to 17, which is far more detailed. Essentially, they allege here the products manufactured by Conklin were defectively designed or manufactured, and that's really about it.
So in your view, they need to explain in detail in the complaint at this stage of the proceedings what was in the fertilizer, what herbicides or what chemicals were in the fertilizer that shouldn't have been there?
Well, I think they have to say, and perhaps not quite that much detail, but they have to say that it was not reasonably designed, in that perhaps components were in there, weren't in there, that shouldn't have been in there, and the reasonable, feasible design existed without that. And also, obviously, that it left our control in that state. And similarly, on manufacturing defect, you're required to allege it's not built to certain specifications. It differed from that in some way. You know, this is, you know, if you look at the Soule case, which is in our brief at 16 to 17, it's far more detailed and still conclusory. And this is entirely conclusive. There's nothing in there that supports that they've even pleaded. If their cases don't even involve, the cases they cite, for example, in contrary to mine, don't even involve pleading of a strict products liability claim. They involve products liability cases at best, but not whether one's been sufficiently alleged. So I think it fails for that reason initially.
Well, they did allege that as a result of the product defect, whether it's manufacturing or other, that something really bad happened, okay? That there was, you know, that the effect of it was to destroy crops and ruin their reputation. I mean, they may not know at this point, but isn't it enough that they allege that an effect happened from the use of this product?
From the cases we cited, that's not enough. Just to say your product had a defect and it was damaged. That's not enough. You look at the Flores case, you look at the, in addition to the Soules case, there's a second department case we cited, page 15 of our brief. You have to allege more about that. There was a defect, a better design existed, some basis for it, not just you had a defect, I was hurt.
And those were all 3211 motions that you cited?
They were. Soules was a 3211 motion. Yes, Your Honor. Correct. Secondly, you know, and I think it's interesting, kind of my third argument ties in with the first one a little bit, but I'll get to that. The Supreme Court erred in not dismissing the tort claim based on the economic loss doctrine. Over 40 years ago in Cayuga Harvester, the Alice Chalmers, 95 82nd 5, that's 4th Department, 1983, court held the law settled that loss of crops are economic damages from which you can't recover in tort. And that's, you're into I think the court below looked at it very simplistically, right? Like as long as you can invoke, there was other property, then you're out of the economic loss rule, and you're not. The court, in many cases, where you're talking about the function of a product, whereas, for example, Ralston Perina, this case as well, 158 82nd 964, dismissing strict product liability claim against roof manufacturer for damages to the building and the contents within the building. Hemming v. Certainty, reversing and granting motion to dismiss. Similar, failure of a siding and it caused damages to clearly other property. Okay, if it really involves in the something the product's supposed to do and it fails, instead of helping my products failed, it is covered by the strict products liability claim. And there's a reason, because, and I think the court will appreciate this, if you allow it for many products, if you allow it something which relates to its function and something it's supposed to be applied to be other property and allow tort claims, it swallows the rule in every case. This isn't the case of, for example, it's funny because Cayuga Harvester was actually a harvester, but in the case of a vehicle, right, you could have failure of the vehicle, and then I could see how products liability might be different. Okay, but in this case, anything, whether it's a waterproofing or a fertilizer or anything else, it's the products. If the products fail or somehow rot, and that was the case, by the way, LNS, I also cited.
Well, let me give you an example, just because I spent some time trying to understand this. This doctrine, economic loss doctrine. If I buy, say, a dishwasher.
Sure.
And it's defectively manufactured or designed.
Yep.
I bring it home, turn it on, and due to the defect, it floods my house, causes all sorts of damage to the house, flooring and whatnot. I can sue, and I sue the manufacturer. The product's liability, you gave me a defective dishwasher. You're telling me I'm limited because I'm seeking damages. I'm not trying to get the value only of the dishwasher. I want damage to my house. You're saying that this economic loss doctrine will preclude such a claim?
It precludes the claim when it's not, and there's a long series of citing cases, Archstone, I think the Edeker case it's in this department, it's not from this court, it's a lower court, where some type of pumping system failed and caused exactly the kind of damage you are referring to, Your Honor. Edeker is in my brief at, get it for you. It was Commercial Division, Erie County.
But the bottom line answer
is yes. The bottom line is yes. If it's not something like it's different, for example. Now, there is a gray area, there's no question, where it goes and something explodes and it damages something which isn't related to it normally, or something related to its function. Yes, you can have those. And
so in my case, I could sue for the damage to my house.
Your case is a better one for the plaintiff than my case, than the case here.
How about buy a car?
But it's close.
You buy a car, there's a defective wiring and so forth. I bring it in my garage,
Sure.
it catches fire, it burns down my house. Does the doctrine, economic loss doctrine, preclude me from recovering for my house?
There isn't a case right on fire, but there is a case on water damage, right? From a roof failing and damages everything in your house. And that was Hemming v. Certainty from this court.
Right.
And the point is, sorry.
That case said that, failure of the product to perform its intended purpose.
Right.
The roof is supposed to protect water from getting in the house.
Sure.
That was the purpose, et cetera. Here, the purpose is fertilizer.
Sure.
And it's designed to increase the yield of the crop. So if you were to put the fertilizer on the crops and it didn't increase the yield, and they say, oh, gee, we paid for this. We thought we'd get X number of dollars. We didn't. We're going to sue you for that. You could say, no, economic loss doctrine. Because the product, all you're claiming is that the product failed to do what was intended. Here, we have the metaphoric explosion. We have the product doing something that it wasn't intended to do, not only not increasing the yield, but destroying the crops. Why shouldn't we then take that further?
Well, because there is another element of when something is applied to something, incorporated with something. And by the way, Cayuga Harvester, that was a failure of a harvesting machine allegedly causing waste and spoilage of corn crops, right? Not that we're suing you because we didn't get paid for the corn. We couldn't collect, it didn't work to pick it up and put it somewhere, right? So, as both your questions are very good, that we're in the gray area. There's no question. But I think in this case, and especially in the case of crops, and I cited a bunch of cases, which I know they're not controlling in this court, but in the Midwest, the breadbasket of the world, they see a lot of these cases. And universally, the loss of crops based upon something applied to them is economic damages. And they have a contract claim, and you can recover by contract.
Maybe the law on economic loss doctrine is a little different state by state, but I think you put your finger on the question is it as simple as I'm not seeking damages for my product here, which is the fertilizer. I'm seeking damage for some. We know if there's personal injuries, then this doctrine doesn't apply, right?
Correct.
That's most of our strict liability. So it's just economic loss.
Yeah.
Is it as simple as I'm not seeking to recover damages for the product that I purchased from you? I'm seeking to recover economic loss for some other item. Is it that simple? That's what the trial judge said.
Yeah,
In
that's-
one of our cases where we seem to suggest it was that simple. You're saying it's not so
Well,
simple.
to the contrary,
Yeah.
that's well, not to the correct on the first point. That is how the court below saw it. Correct. Incorrect. That's how the court. Cayuga Harvester, Ralston Purina.
How about
Okay.
electric waste?
Electric waste was a mercury poisoning of something different that it wasn't supposed to be applied to. And again, Judge, this is, as I said, you're in between a couple points here. I think this one falls because it's a crops and because of Cayuga versus Al's Chalmers and because of the uniform treatment. And the economic loss rule tends to be pretty uniform actually across the states. They don't want contract to drown in a sea of tort and to allow people to always be able to not contract for a warranty. Keep in mind, they pled a warranty claim against us first and then they dropped it.
So you don't think we have to overrule electrical?
No, I don't think so at all. I think you're holding.
It's a different fact pattern.
Absolutely. I think the holding is absolutely consistent with Cayuga, with Ralston, with Hemming v. Certainty, right on point. And those cases are closer. Now, as the court, everyone here knows, the cases are based on facts, right? And I think these facts are squarely within Cayuga and not within electric. So I don't think you have to rule it at all. I don't think the court is breaking new grounds.
If your client manufactured fertilizer.
Yes.
And it contained harmful herbicides that are just going to destroy any plant alive.
Sure.
And a farmer buys it and they spray it out. There's the only remedy for the farmer loses the entire farm, all the crops. On every acre.
Sure.
All the animals in this area dead. Cows.
There's no claim for damages for that.
No, I'm just saying in my hypothetical.
Okay, sure.
Because there are dead animals here, but not.
Well, that's interesting. I thought you'd catch that.
Yeah.
He threw an animal in there somewhere. First of all, as you know, that's chattel. It doesn't get to personal injury. But anyway, he threw an animal in there. But if you look at the complaint, paragraph 21 to 22 of the record, there's no claim for damages of loss of animals. He's saying like a neighbor may have lost one. He didn't get sued for it. I think it's a gratuitous tossing.
This case won't get decided on whether animals died or not, but in my hypothetical, all that damage could be caused, all that could happen, and then the farmer's only remedy is to sue for breach of warranty. I want my money back on my fertilizer I bought from you.
I think as far as it concerns the crops, correct.
So they're out, all that money is just tough luck. Yeah, we gave you a terrible product that killed everything that you own, but here, we'll give you your money back for the fertilizer. Everyone's happy.
If we were the seller, he'd have a remedy against us. We're not the immediate seller. There's no question. He's got a remedy with the immediate seller. I don't know what the terms of that contract, that's not my business. Okay. But when you, if it's just the crops, the cases are pretty clear.
Okay.
Okay. So anyway, the third reason, which is interesting because it ties into the other stuff a little bit.
But under Judge Lindley's,
Sure.
Hypothetical, if the contracts, limited consequential damages, then his result will hold, right?
Essentially, in most cases, meaning he could recover normally under your situation, Judge Greenwood. They could recover for the cost of the product, but not the consequential damages therefore, if it were a valid disclaimer. Now, as the court knows, there are many things required for such disclaimers to be valid and enforceable, right? And whether they could meet that burden or not isn't my client's argument here. But that's, yes, if that held up, correct. And also, as you also know, because at this, the price, that's factored into the price of the product, obviously. Many times when you buy a product, right, you're outside of personal injury or the rare type of property damage that gets you out. So no one's going to sell a $100 product and risk losing their whole business, without proper contract limitations. So it's not wrong to do that. Finally, last argument, and this is kind of an interesting one, in a way, a bit of an old-fashioned one. Under CPLR 3014, a copy of any writing which is attached to a pleading is a part thereof for all purposes. And as set forth in my brief at page 30, a statement in a pleading, which is what happens when you attach the kind of thing, is a binding formal judicial admission, which unless amended is controlling. They allege that they tested the product for herbicides and that a complete copy of the same is attached as Exhibit D. And if you look at their report, it found, and it searched for more than 3, but it found only 3 herbicides, and they were herbicides which are common in agricultural settings for selective control of broadleaf weeds in corn, hayfields, or pastures, small grains such as wheat and turf, page 44 of the record. Now, so based on their own testing, what they made part of their pleading, however these herbicides got in there, is they could not have caused the damage alleged. People spread the stuff on hay all the time.
If those three herbicides, the 2,4-D, dicamba, and MCPP.
Yes.
Wouldn't have caused any damage to the crops.
No.
Something else did, because they sprayed in one area, everything's dead. They didn't spray, they didn't have enough of the fertilizer, sprayed another, everything's fine there.
Well, that's not, I mean, they tested it. They claimed that this is all it had. And that is, now in their reply brief, okay, they did allege, well, maybe what about this? What about this? They injected new things, but those weren't pleaded in any fashion a complaint. You can't do it in a reply brief. So my point is, I think that ties into the fact that at core, even by their own admissions, this is the testing, this is what's in there, it fails. So based on all those three arguments, Your Honor, I think the court below should be reversed. Unless the court has any more questions, I'll rest.
Thank you, Counsel.
Thank you.
Mr. Miller. There's a lot there to respond to.
Andrew Miller for the plaintiffs. I'll keep my remarks relatively brief. On the first issue of whether or not we've properly identified the defective product, as the court just noted, attached to the pleading is a copy of the chemical analysis that includes the herbicides that were found as part of the testing. And so the quite obvious issue is don't sell fertilizer that has herbicides in it. I think it's pretty clear that we've adequately identified the problem with this product.
Well, they say that the herbicides that are identified in your attachments would not cause crop damage of this nature.
First of all, resolving that on a 30-11 motion when we don't know the density or the amount of the herbicides. We have a mixture of herbicides. We have they're being applied to emerging crops. There are a litany of questions which we raised to the court below, and the court agreed with us that at the pleading stage of a case, you're not able to resolve these types of issues.
Are those types of herbicides supposed to be in fertilizer? It would seem like the opposite of fertilizer. Fertilizer helps. Herbicides kills plants. It seems odd that you would have that here.
Our client did not anticipate having these herbicides in the fertilizer products that it purchased.
All right. How about this theory that you're seeking damages? You're limited only to the damages of the product here.
I think the case law is very clear on this, that when a product causes damage to property other than the product itself, it falls outside the scope of the economic loss doctrine.
Opposing counsel raised Cayuga Harvester, and I saw that you addressed it kind of briefly along with other cases on page 13 of your brief, but it seems to me, so Cayuga Harvester was a case involving wasting and spoilage of crops when a harvester didn't perform as anticipated. They didn't, it does seem analogous here. I mean, how would you distinguish it?
Sure. Well, this case goes beyond just crops, right? It goes to soil. It goes to animals on the farm that were harmed. I think this case is much more akin to the U.S. Energy case, where the fracking fluid was applied and it damaged the wells such that the fluid was the wells were no longer as productive. And to your point earlier, Judge Nowak, which was that the purpose of these fertilizers is to increase the yield. And here, it not only did it decrease the yield, it caused additional harm, such that the subsequent cuttings were, as alleged, were damaged. We have potential damage to the soil itself. And I know Mr. Zarlak suggested it was a throwaway. There are dead animals. Whatever occurred here was pretty dramatic. So this is clearly outside the scope of the economic loss doctrine.
You want some discovery to find out exactly what was in the fertilizers and feel you're entitled to that, and maybe we'll see you back on summary judgment.
Correct.
All right. Thank you, Mr. Miller.
Thank you.
Thank you, Your Honor.
Case 931 is Rogers versus DS Restoration and Residential Services, 931. I'll argue 932 with it.
Good morning, Your Honors. May it please the court, Jill Allen from Rep Falls Graph on behalf of the defendants, or Mr. Dabney and DS Restoration. This case arises from a fall from a ladder while cleaning out the gutter on a residential home. It's undisputed that statement, that's what happened. That's what happened here. So is the fact that gutter cleaning is not a protected activity under Labor Law 240 sub 1, nor is it construction, demolition, or excavation work under Labor Law 241 sub 6. Therefore, we're kind of beginning this case with the idea that the plaintiff was not performing a protected activity at the time of the incident.
Unless it was repair work, right?
Pardon?
Unless it was repair or cleaning, those would fall within the scope of 240 sub 1.
Exactly, Your Honor. So that's the issue here, and that's the plaintiff's argument, that the scope of work wasn't just gutter cleaning, that the scope of work involved a repair, which then would bring the gutter cleaning, the unprotected gutter cleaning, in the purview of Labor Law 240 sub 1, or, arguably construction, demolition, or excavation work for 241 sub 6. And then that way the gutter cleaning would be protected.
If it were just straight come clean my gutters, it's not protected activity.
Correct. And
This is, and we've held that before, and you don't disagree with that. It's
right.
This is that soffit where animals were getting in above the gutter.
Right.
Seems to be some factual issues of, was that part of the scope of the contract here? Such as it was.
And that's exactly what the issue is, Your Honor, that there's an oral contract. The homeowner here, Renee Pasquica, she sends out a request on, it's called the Nextdoor app, and says, I need my gutters cleaned. My client, Leonard Dabney, responded and said, come clean out your gutters. They met at her home. They talked about the gutter cleaning. They decided it would be $450 for the work. My client leaves. He contacts the plaintiff and says, hey, would you like to come assist me in cleaning out these gutters? So they show up there. Plaintiff and Mr. Dabney go to Ms. Pasquica's home on July 13th, 2020, to clean out the gutters. That's it.
But Mr. Dabney didn't he go to what was it, Home Depot or somewhere like that to get some, and then Mr. Rogers climbed up the ladder while he was getting the repair material. And that's when.
So to address that issue, Your Honor. So again, they go to the house that morning on July 13th, 2020 to clean out the gutters. That's it. They do the left side of the house first, all the way from the back to the front, clean out the gutters. They do across the front, clean out the gutters. They get to the right side of the house. They do from front to halfway back, just cleaning out the gutters. They don't know they're doing any other work at this point. They're about halfway down the right side of the house. So left, front, and right side, first half of the right side is finished. There's 5 to 7 feet of gutter left to be cleaned. That's it. Mr. Dabney climbs up the ladder and discovers this hole. So he says, hey, I'm going to, Ms. Pasquica's a, single woman with this daughter. I'm going to go repair it for her. I'm going to patch the hole. And I'm using the term repair here because obviously in my, my other position is that patching a hole is not repair work, and that also is routine maintenance. But just to continue on, he says, hey.
At that point, did it change the scope of the work? Didn't it leave the cleaning gutter into something else?
So, Your Honor, if to address that, if at that point it changed the scope of the work, one, the work that was going to be performed to the hole was patching it, buying one piece of aluminum flashing, placing it over the hole. That's not protected repair work either, according to the cases.
I thought the plaintiff said something about taking out the old wood behind it, gaining access, having to remove the gutter. He went on. I'm looking at 175, 176 of the transcript.
Right. None of that work was ever performed. None of that work was ever contemplated before to be performed.
So we should disregard the plaintiff's testimony instead of giving it full credit on a motion for summary judgment. That's different than what we usually do.
Correct, Your Honor. But here's the issue. At his deposition, plaintiff was asked, why did Mr. Dabney go to the store? What was he going to get to address this hole? He didn't know. He doesn't know the materials. Then he's asked later, did you do any work to the hole? No. Did you see the work being done to the hole? No. Do you know what work, if any, has ever been done to the hole? No. For all he knows, the hole still exists. It was never even addressed. He testified he has no knowledge of the materials that Mr. Dabney was going to get to address it or to any work that was being done for it. Then he submits these, and I'm not trying to, I don't say this lightly, but these self-serving, conclusory, contradictory affidavits that basically state things that are untrue, that all of a sudden the fascia board had to come down and had to be repaired and had to be painted and caulked and something. And one led from the next of what had to be done when none of that work was ever performed.
Do I have this right that Mr. Dabney testified that when he arrived at the job, he looked at the exterior of the house, he saw a hole in the soffit where the birds were coming in and out, and he told the homeowner about it. And then his testimony is he pretty much went to take care of it.
He did that, Your Honor, 2 to 3 hours into the job after they did the left side, the front side, the right side. So 2 to 3 hours into the job.
Arrived at the job, looked at it, but at some point he sees this work, this repair work. You would agree that that's repair work?
I do not agree. It's because it's patching a hole. All he did was place a piece of aluminum flashing over it.
So it doesn't matter if it was in the scope of the contract at all, because it's separate. None of it's repair work in your view.
Right. Right, exactly. Because it's separate. I mean, what is repair work? Repair work is something that's inoperable.
What if you take off all the gutters to access the soffit, then take the soffit off and you put some flashing on there, put the gutters back up?
Arguably, if you're asking me if that would fall under the scope of repair work, potentially it would, but that's not what happened here. That did not happen. The gutter did not come down. Mr. Dabney is the one who performed the work. The gutter never came down. It never had to come down to ultimately address this hole, which was putting a piece of aluminum flashing over it to patch it. And that's all he did to it. And that's why, the work that's done here. So to address your question, Justice Nowak, did it change the scope of the work? Potentially, but did it change the scope of the work to what? To repair work? No, it changed it to patching a hole, which is not repair work. Also, the other thing here is what the plaintiff was doing at the time was cleaning out the gutter, an area of gutter that had to be cleaned out from the original scope of work. Regardless if the hole was ever, discovered, addressed, whether it existed or not, the actual activity that the plaintiff was doing, cleaning out the gutter, was the original job. So it has nothing to do, it's completely separate from what work was done to the hole, because again, the gutter did not need to be manipulated in any capacity in order to patch this hole.
We understand your point there. Do you want to touch on sole proximate cause before you sit down?
Sure, Your Honor. So, just to touch on that, as you said, plaintiff here, he says that he's in control of his own work. He made it all his own decisions. So, there's many examples that I put into my brief of all the ways that, he chose the means and methods of his work. He chose what to do. He chose what to not to do. He didn't have to perform any of that. And I wanted to kind of go back and to touch on Justice Nowak's, or just the question here about the affidavits and all the list of repair work. Plaintiff said he didn't need to use a ladder on his job. At any point, he didn't need to go up onto a ladder at 186 South Ogden Street. That was not in the scope of his work. If that repair work that's listed, gutter coming down, for example, plaintiff would have had to get on a ladder. There would have had to be 2 ladders. He would have had to get on the ladder on the one side and they would have lifted it down. He testified that would have happened. He also testified he did not need to use a ladder at any point on the job. That was not, part of his job duties. So to go with sole proximate cause, plaintiff chose everything he did that day. Mr. Dabney leaves. He does not need to go up if he doesn't want to. He chooses to go up to continue to clean out the gutter, the original scope of work, rather than sitting around. Understandable, but he chose to do it.
You say clean the gutter.
Correct.
Cleaning's a covered activity under the statute, right?
Not,
you mean to say it's just routine maintenance, cleaning the gutter?
right. He just went up to cleaning out the gutter. That's what he did. He went up the ladder. He had a bag in one hand and a scoop in the other hand. He's standing up on the ladder. He said his chest was up there. He's about 5'8". So he said he didn't know what rung he was on, but he's 4 or 5 rungs up. He has a scoop in one hand, a plastic bag in the other, and he's cleaning out the gutter. He's up there for about 15 minutes. He hears birds in the hole, I should say. kind of sees apparently birds in there, kind of coming towards the hole. They don't actually come out of the hole, but fearful that they're going to, he shifts his body to the left. He causes the ladder to move. And then he did a kind of lost his balance, jump back because he smacked his left wrist on the air conditioning on the house behind him. So he kind of did a jump back, and then lands underneath the ladder. In our brief, we pointed out he didn't have to go up if he didn't want to. He chose to do it. To the extent he argues that this ladder was unstable, again, he doesn't have to go up. He chooses to do it. The ladder wasn't unstable. It had a stabilizer on it. There's talk about a boot being missing.
Shifted.
Pardon?
The ladder shifted.
He caused the ladder to shift by shifting his weight outside the rails, which is a misuse of the ladder. You have to stay within the rails when you're standing on it. When he shifted his weight to the left, that's when the ladder moved. Once he did that, the ladder kicked in. Had he been holding on, because you're always supposed to hold on at least in some capacity, wasn't holding on at all. That's why he fell. So he is the sole proximate cause for many reasons, at least, again, in our opinion. Kind of going down with why also Labor Law 241 is the activity was not covered. He's the sole proximate cause, and there's no violation since the ladder didn't fail. With regards to 241-6 or 200, if any of your honors have any questions, I'd be happy to address them. If not, I can rest on my brief for those issues.
Right. Thank you, Cal.
Thank you.
Good afternoon, Your Honor. May it please the court. My name is Christopher Pinozzo, and I represent the plaintiff in this case. I think Justice Nowak made the point previously. This is an issue of fact, Your Honor, and I would dispute defendant's version of when this hole was discovered. Plaintiff testified he knew about the hole. The next door neighbor who testified said he knew about the hole.
Before any work was done?
Before the work was done.
When he talked to the homeowner and negotiated this price?
Not the homeowner, the next door neighbor testified that he was aware of the hole.
Right, okay, the next door neighbor.
Yes.
Did the general contractor testify that he was aware of the hole before the work started?
I believe he did testify to that, Judge, after I showed him a prior sworn statement where the idea of the job included patching the holes behind the soffit.
So you dispute the fact that he learned about it after doing this side, that side, the other side, and then, oh, here it is. You say his testimony and the evidence shows he knew it at the beginning.
His testimony, the plaintiff's testimony, as well as the next door neighbor's testimony of all those. And this is clearly, the court would have to disregard at least two witnesses and probably the defendant in this case in order to find that this was not a covered activity.
Well, she says even if the soffit work was within the scope of the contract, it's not repair work, it's routine maintenance.
I think that there's case law, Judge, that is discussed that in the past. The Verhoff case, which was from the Fourth Department last year, I think speaks to that. I believe the Davidson versus Abramowitz case is very similar to this. When it goes into malfunctioning or inoperability, what is the idea of a soffit? The idea of a soffit is to protect from water and protect from pests. One of the things it was not doing was protecting from pests. There's no dispute that there were birds inside of this soffit. So in that case, the work that needed to be done ultimately, and my client testified that he was doing this work in order to take the gutter down, in order to repair the soffit. And Judge, I could speak to any other sections of my brief, but unless the court has any questions on any other section.
Thank you.
Thank you.
Case 933 is Luciola versus Rochester Regional Health. 933. We're waiting for your opponent to appear virtually. Ms. Bob, you may proceed.
Yes, thank you, Your Honor. Well, good afternoon, I guess now it is to all of you. May it please the court. My name is Claire Bopp from Von Schoening King, and I represent the defendants appellants in this case, Rochester Regional Health doing business as RGH, and Dr. Kevin Reville. Your Honors, defendants respectfully request that this court reverse the trial court's decision in order denying our motion for summary judgment because Through the expert medical affirmation of Dr. Reville, it's clear that we have met our prima facie burden, establishing that there was neither a deviation from the standard of care in this case, and that plaintiff's alleged injuries were not caused by any alleged deviations in the standard of care, and that plaintiff, through her expert, Dr. D'Ambrosio, wholly failed to raise tribal issues of fact as to both elements in this case.
It seems that the plaintiff's expert is arguing that because of this intractable pain that the patient expressed 10 pain, even after the morphine was given, the IV, that was a clear indication that at this point, you've got to go in and do some testing. You've got to go in additional testing. You've got to go do, I think it was a CT scan at that point to try to get to the bottom of that, of why that's occurring. That shouldn't be the case.
Your Honor, that is what Dr. D'Ambrosio, in a nutshell, says, perhaps not as eloquently as you just did. But what he fails to address, in that's really his only standard of care opinion in opposition to Dr. Reville. He fails to address Dr. Reville's opinion that pain alone is a non-specific complaint. He sees countless hundreds of people who come in every day to the ED with abdominal pain. So you have to look at a patient with their whole constellation of symptoms. The plaintiff here exhibited none of the symptoms that would be suggestive of a perforated ulcer. And that is something that Dr. D'Ambrosio in his affidavit fails to address. He doesn't explain why pain alone would warrant, in the absence of all of these other things that doctors are looking for when they are potentially contemplating a potential perforated ulcer, that she didn't have, why that would necessarily necessitate having a CT scan done. And to that point, I would just add, and we set forth in our brief, nor does Dr. D'Ambrosio explain what, if anything, a CT scan would have shown.
Well, putting that aside for a moment, would we have to review Dr. D'Ambrosio's affidavit then as essentially claiming that since we don't get into any of the details of this case, this patient, this case, age, et cetera, all the other, the absence of vital signs that were essentially normal at this point, that we would have to assume that based on the opinion that what the doctor is saying is that the standard of care at this time was anybody comes in with abdominal pain at this level, gets morphine and doesn't recover, you have to do the testing across the board.
Right. I mean, Dr. D'Ambrosio's affidavit is not very detailed, Your Honor. I'm not sure exactly what he's saying potentially, but he doesn't explain why that would be. He doesn't even set forth, this is the standard of care. This is what the standard dictates that an emergency doctor should be doing. This is how Dr. Reville fell short of that. All he says is, to your point, in really two pretty conclusory paragraphs, that yes, that because she had persistent pain, he should have reconsidered his differential diagnosis in order to CT scan, and doesn't explain why that would be, and fails to take into account her entire clinical presentation.
And she, did the record show that her pain, she was discharged in the morning. This 10 out of 10 after IV narcotics was at 3:42 a.m. And that's where things went wrong, according to Dr. D'Ambrosio. That's where the differential diagnosis should have been considered. But when the plaintiff was discharged, 6 o'clock in the morning, whatever it was, is it not true that her complaints of pain had lessened significantly?
That is what that's what's documented in the medical record, Your Honor, that she reported feeling better. And so
in your view, does Dr. D'Ambrosio need to take an account of that? Yes, she had 10 out of 10 at 3:42, but she wasn't complaining of pain upon discharge. That seems to be inconsistent with his differential diagnosis. Does he need to reference that or explain that issue of the pain reducing?
Yeah, I would think so, Your Honor. Dr. D'Ambrosio doesn't really address much in the way of anything. I mean, aside from the singular solitary opinion that, you have some persistent pain at 3 a.m. that should have caused Dr. Reville to consider the possibility of a more emergent condition. He doesn't even go so far as to say that there was actually a more emergent condition that existed. And we know, as Dr. Reville explains in detail in his affirmation,
Right.
that he doesn't believe that she had one.
He doesn't say what the differential diagnosis should be.
No, Dr. D'Ambrosio does not say that.
Do a CT scan if he had said, look, that's indicative of an ulcer, perforated ulcer, of having pain after being given narcotics, maybe so. There seems to be, it's one of the shorter expert affidavits I've seen in the practice case here from Dr. D'Ambrosio, but we understand the flaws that you see there. Are there any other arguments you want to make here?
Oh, I think that,
No, I was just gonna say that Dr. D'Ambrosio, if he's alleging that a CT scan should have been, taken, that he's supposed to show what that would have shown, correct? And he didn't put that in his affidavit.
That's right, Your Honor. And that's critical in this case because Dr. Reville, based upon his review of the certified medical records, is that, the following day when plaintiff presents to Strong, she has a whole host of clinical symptoms that she did not present with the day prior when he saw her. And that's really important in this type of a case because ulcers spontaneously perforate. So based
The only
upon.
thing that makes sense from your client's perspective is her ulcer was fine. She did not have any perforated ulcer when she checked in the first time. She did not have it when she checked out the first time. She went home for a brief period of time. That's when the problem occurred. She came back and she was treated. Then we get the whole issue of if it was diagnosed properly on day one, the same surgical intervention would have taken place. And there's some, I don't know if it's causation issues there, damages, but you want to close with some thoughts on that.
I would be happy to, Your Honor. You hit the nail on the head. That's exactly Dr. Reville's expert medical opinion, that it perforated in that intervening time period when she went home. And even assuming, for the sake of argument, that she had a perforated ulcer when he saw her in the RGH-ED, her clinical outcome would be the same because the only treatment that you can give to a patient who has a hole in their small bowel is to surgically repair the hole. And so any alleged delay, the 1 day alleged delay in diagnosis had no clinical significance in her outcome. And this is another issue that plaintiff's expert fails to address at all. Dr. D'Ambrosio says absolutely nothing about that. And thank you, Your Honors.
Ms. Tavera.
Good afternoon. Without trying to make the standard, a watered down one, what we are required to provide is indication of a triable issue of fact. The question about when the ulcer perforated, etc., those are matters that are for the province of the jury. And I disagree. Our client, or our expert, clearly indicated, although briefly, succinctly indicated that when someone has pain, a 10 out of 10, and not just that, but stomach spasms that have gone basically, unmitigated despite some pretty heavy pain medication, that in and of itself is a reason to do a diagnostic. I know I would want somebody to do a CT scan on me or some appropriate scanning on me if I complain of a 10 out of 10 in pain. And the fact that we didn't follow lockstep with Dr. Reville's affidavit is of no consequence. We've indicated we don't have to accept his argument regarding what caused or when the ulcer occurred. We don't have to follow his timeline. Our doctor basically indicates something was wrong, something was terribly wrong, and something should have been done. We shouldn't, and certainly should not have sent her home. The idea that she, that this would have been the same thing, it's just a day later, it ignores the fact that there could have been a better outcome. There would have been a less invasive surgery. There's a significant scar now where there could have been, a different procedure done if it had been done earlier. I mean, those were things that were in our brief.
Counsel, I don't see anything from the doctor's affidavit that talks about different procedures. It seems that, doing a CT scan isn't something that necessarily is going to change you're going to have more information, but it's not necessarily going to change your treatment. After you do the CT scan, depending on what you find, something else needs to happen. And it seems the expert doesn't really lay it out. It seems to me that either the CT scan is normal, in which case she's probably discharged, which is what happened anyway. It shows the perforated ulcer, in which case she's going to go and have the surgery that she ended up having anyway. And then we might be talking about that, you know, if she had it a day earlier, 20 hours earlier, it would have been less in some way or would have been caused less pain. But we're not really there because we don't have that argument laid out. And then the other thing that frankly I was expecting was, well, it's going to show an ulcer that has not yet perforated. You say, okay, well there you could do what? Treat, you could prevent it from perforating, you could do all kinds of, that would be a great opinion, but that I don't see either. So how are we to try to understand what the expert has shown?
I feel that the expert has set it out, Your Honor, in paragraphs 24, 25, 26 of his affidavit at page 170 of the record. You know, failing to reconsider in the face of the pain, he's indicating that you know, the deviations deprived her of a substantial chance of a better outcome than developing overt peritonitis and requiring life-saving emergency surgery the following day. The implication here is clearly that there was a perforation when she first presented herself, you know, on October 1st, and that she suffered with that until late in the afternoon of the 2nd and returned to the hospital. The fact of the matter is that there is an indication here that something more should have been done. And again, I think that it, again, although succinct, I do think that it's clear and it is addressed. And this simply raises an issue of fact. And once an issue of fact exists, then it has to be popped to the jury to decide. And you know, it's clearly here in the four corners of his affidavit.
The thing that the record reflects is that after this happened with the report of the 10 out of 10 pain, Dr. Reville came in to give her, I think it was Norco, and maybe the other pain medicine, Toradol as well. Neither of which she ended up getting because she declined the Norco because it was an oral medication, and the Toradol, I don't think there was enough time had passed. So she needed like 6 hours to pass when she got it when she first came in. So she didn't get any of those pain meds. She got ibuprofen. And then her pain went down to 4 out of 10. And the doctor, the plaintiff's doctor doesn't even comment on that. Don't they have to? Don't they have to explain why the pain went down in some fashion? Because that's why she ultimately was released.
Well, it's just that it's singularly striking to the doctor that since 3:42 a.m., after a morphine, an IV of morphine and the Toradol, she's not responding. I understand what Your Honor is saying, but I think that window in and of itself is significant for our expert. He doesn't talk about the discharge. I agree with that. I can't manufacture or put words in his mouth, but he is very clear that in an emergent situation, it was made worse by ignoring that pain.
Do you think does Dr. Reville have any explanation for the 10 out of 10 pain report at 3:42 a.m. after heavy doses of IV narcotics? Does he have any explanation for why that could be? And is he supposed to have some explanation for that? Because that does seem unusual.
Yeah, I didn't see it. I just saw like basically this check in the box type approach to, well, I looked at this and I looked at this and I looked at this. I just, I don't know that we can always just discount. I didn't see it, to answer Your Honor's question. I don't want to do a dance, but it is, to me, like I said, a 10 out of 10 is quite striking, and it would seem to me it would indicate an issue that is much more significant than just to treat with ibuprofen. She's there, she's in the hospital. you know, there's no indication of why a CT scan was just not done. I mean,
Right. I would have liked to seen a response from Dr. Reville is, I didn't order a CT scan after the 10 out of 10 pain early in the morning for these reasons. It was unnecessary. There's other explanations. I would have liked to seen that. I don't know if it's required, but it does seem a little unusual that somebody would have that type of pain after being medicated in such a significant way.
that's our position.
All right. Well, thank you for your time.
Thank you.
Last case on the calendar is 934, matter of estate of Merle S. Watt Sr. Good afternoon, Mr. Bobbitt.
Your Honors, may it please the Court, Daniel Bobbitt, Zdarsky, Splicki, Gustinelli, appearing on behalf of objecting appellant Melinda Palmer. I'm here today on behalf of my client to ask this Court for three things: reversal of the surrogate's grant of summary judgment, vacating the letters testamentary issued to Sidney Watt, and remanding this matter for jury trial. Your Honors, when I sit down, opposing counsel is going to stand up and she's going to, I think, stress to this Court the importance of the evidentiary presumptions that apply in a will contest case, which is what this appeal is about. But I would submit to Your Honors that presumptions must yield to facts. The lower court, as set forth in my briefs, disregarded those facts and deprived my client of a jury trial to which she is entitled. I just want to highlight a few of these facts for the Court that the lower court disregarded. Fact number one, my client was the only one to come forward with an expert, a neuropsychologist from Penn State with 30 years of being a professor at Penn State, who studies the link between the brain and behavior, submitted an affirmation based on the medical records to indicate that at the time of the execution of the will, the decedent lacked the cognitive ability to understand the nature of what he was doing and the consequences of what he owned.
Counsel, didn't Ronald Fox testify that the decedent appeared at his office in good health and good sound mental capacity and by himself at the time?
Correct, Your Honor. Judge Plotz did testify to that at his 1404 hearing. What was not, so let's assume that the presumption of testamentary capacity applies, and I conceded in my appellant's brief that it does. Okay, so the presumption applies for testamentary capacity. However, as raised in my papers submitted to the lower court, we had affidavits submitted by my client, who's decedent's daughter, the decedent's son, Merle Watt Jr., who has since died, Lucy Ray Watt, the ex-wife of the decedent, who remained close friends, who indicated that around the time that the will was executed, there was a change in decedent. The way that he was isolated, the decisions that he would make, he was not himself as he exhibited throughout the course of his life. So it doesn't matter with the snapshot in time, an hour in the attorney's office. You have to look at what Dr. Arnett says is that dementia is a progressive disease. So the respondent identifies in her brief represents that there was no medical record reviewed by Dr. Arnett that predated the execution of the will. That is proven wrong by the record. There's a 2004 CT scan where there are material indications of abnormalities in the frontal lobe in 2004. Like I said, dementia is a progressive disease.
All that stuff is true, but the standards of the courts that have applied with people with dementia is very low. And so it's like, okay, maybe there was dementia, maybe there wasn't, but what else do you have? I
Well-
mean, there's, there's no, where's the proof of undue influence and all?
Sure. So undue influence, Your Honor. I think the lower court applied the wrong evidentiary burden and assigned it to the wrong party. I submit that it was Sidney Watt's obligation to prove the absence of undue influence, given the close confidential and fiduciary relationship between daughter and father. They were business partners. She was his power of attorney, his caregiver, as set forth in the record by the affidavit submitted by my client and others. Sidney was able to subtly exert influence over the decedent in such a manner that was inconceivable to the family prior to this time in his life.
You say inconceivable, but Attorney Plotz, now Judge Plotz, had an explanation for that from the father, who seemed to indicate he wanted to level the playing field. He had already given business assets. Melinda and Merle Jr. had taken their interest in the business and left, cashed out, if you will. And Melinda hadn't, Sidney hadn't at that point, right? So from the father's business, I know they're business partners and so forth, but it sounds like the way Mr. Plotz looked at it was that Merle said, Melinda and Merle Jr. are okay. They've got their assets from the business. Sidney doesn't have any assets from the business, so I'm going to level things out. That doesn't sound totally unreasonable, does it?
It doesn't, Your Honor, but I think you have to view the entire record. And one of the things that Judge Plotz also said in his 1404 hearing was that he did not understand the nature of the partnership. He said that in his office, the decedent told him that he had given certain lifetime gifts to Melinda and Merle Jr. He did not. When Melinda and Merle Jr. left the partnership, they took what was theirs.
Well, I know, but they took substantial assets from a business they had with their father, and they're financially set. Is there any indication record how much the value of the assets they took when they cashed out of the business, so to speak?
No, Your Honor.
So let's say they each got $5-10 million. And it would seem to be relevant. Merle's thinking, well, Sidney's got nothing right now. So why would I split it three ways with Melinda, Merle, and Sidney when Melinda and Merle already have a lot of money? Your answer is going to be, their answer is, well, it wasn't his money, it was our money because we were in business with him. I don't know the truth of that, but I guess your point of view, that's why we need a trial here.
I can't answer that question, but the jury can. I think that's a jury question, and viewed in the totality, Your Honor, and I would just stress one more time for the court that evidentiary presumptions must yield to facts. And because there was no expert presented by Sidney Watt, I think that's uncontradicted. Dr. Arnett's name is not mentioned once in the surrogate's court decision in order, and I think that was a clear error.
Thank you, Counsel.
Thank you.
May it please the court, Melissa Pizzino for the respondent, Sidney Watt. Sidney Watt is the executor of the decedent's will. She's also the sole beneficiary under the will. We disagree in the sense that we believe that decedent transferred business interests to his other children during his lifetime, and that is why he chose to leave the residuary clause under his will to Sidney. The appellants may disagree with his decision to do that, or they may feel that they were entitled to that under partnership law. But the fact of the matter is that decedent did not feel that way. He indicated that to Judge Plotz, and Judge Plotz testified to that in the 1404 hearing.
Do we know the value of the estate?
I do not know the value of the estate.
In a lot of these cases, we'll see videotapes now of somebody who's executing a will in the lawyer's office, though. And that's helpful. I like to see that when we're trying to determine whether somebody was competent or not. We don't have that here, I take it?
No, that's that's not my standard practice. I don't know that that's necessarily popular, but I do see how that could be helpful. Usually we.
Not treating, when you're disinheriting somebody,
Mhm.
it would seem to be prudent for him, if I'm doing a will, I would want to explain why I'm doing it and being asked questions. I don't know, but we don't have that here, so it's irrelevant.
Right. I usually will actually like write a memo like to the file saying what the person told me, the reasons for that. But we don't have a video. We just have Judge Platt's testimony, and he was familiar with what had happened at the time. There's also a presumption that the will is valid when there is an affidavit of a testing witness. And also, the law is clear that a testator is presumed to be competent. So, I think those presumptions are evident here. I do want to respond to the issue of the medical expert. The proffered medical expert, reviewed the decedent's medical records. He did not examine the decedent. He had no treating relationship with the decedent. He never spoke to any doctor who had a relationship with the decedent, and that makes his testimony not very useful.
He reviewed medical records.
He reviewed
MRIs,
the records, and I'm sorry.
Yeah, I thought there was other evidence, concrete evidence that he reviewed. He did the best that he can, seeing that he wasn't the treating physician.
Yes, and the case law says that the opinion of a medical expert having reviewed the testator's medical records is insufficient to raise a factual issue to defeat a motion for summary judgment. That is in matter of Kumstar, also Estate of Van Patten, and also matter of Newman. All three of those cases hold that a medical expert reviewing medical records is insufficient to raise an issue of fact to defeat a motion for summary judgment. So I think that the case law actually settles that there's no issue of fact raised in that regard. Also, I just want to address the argument as far as undue influence. The argument is that the burden shifts to the respondents in order to prove that there's no undue influence because there was allegedly a confidential relationship between the respondent and the decedent. There's no citation to support that there's a confidential relationship between a daughter and a father or business partners. There's no citation in the brief for that. So there's really no grounds for that argument. But even in the case, if there was a confidential relationship between them, the burden only shifts if the person who was the beneficiary actually had involvement in procuring the will. And there is no involvement with the respondent. She had nothing to do with the drafting of the will. She didn't contact Judge Plotz. She didn't accompany him to the appointment. She had no involvement with that. And the court in Bartel states that while the beneficiary, while the burden may shift to the beneficiary if there's a confidential relationship, the court is unaware of any case which has held that an inference of undue influence exists where there is no evidence that the fiduciary legatee had some involvement in the drafting of the will. So I think that the case law speaks in our favor there as well. And with that, I would just, unless there are any additional questions, I would just rest on my brief.
Thank you very much.
Thank you, Your Honor.